বোর্ড ডিসপ্লে বোর্ডও চলছে না।
বোর্ডটা চলবে লাইভ স্ট্রিমিং এগুলো তো সেন্ট্রাল
কিন্তু মাঝে মাঝে আগের দিনও দেখছিলাম চলতে চলতে বন্ধ হয়ে যাচ্ছিল। আসলে সবাই করলে তো এবারে প্রবলেম হয়ে যায়।
এটা মানে
His Lordship, may I need to mention the urgent motion, Your Lordship. Item number 576 to the list, Your Lordship.
Yes.
Your Lordship, the private respondent authority, the irrigation department are going to encroach my land without any notice or prior to notice.
Are you mentioning upon notice?
Yes, Lordship.
Give
The
them.
top in the list, Your Lordship, Monday, kindly, Your Lordship.
Give the number.
My lord, may I have your lordship's kind leave, my lord, to file and move this matter, my lord, on 2 p.m., my lord. The urgency is, my lord, hundreds of people, which includes women, children, old and infirm, my lord, are on the verge of getting evicted, my lord, by the order which is impugned before your lordship, my lord. The order was passed on 11th of January. I have been communicated by on, my lord, 17th of January, my lord. If your lordship kindly permit me,
Show me the order.
my lord.
Lordship, may I permit to mention one matter?
I am in the midst of a matter.
My lord, this is the communication notice. The order follows the page.
Under the 62 Act.
No, my lord, under 64 Act.
64 Act.
The order follows, my lord, the next page.
It's a 13th October order.
Yes, my lord, communicated on 11th of January, my lord. We received it on 17th, Wednesday, my lord. If your lordship kindly turns up the page, my lord, the previous page, my lord. 11th of January 2024 was the order of communication, my lord. We have received it on 17th of January, Wednesday, my lord.
File and give the number, it will be taken up. Since October, nothing has happened till today.
No, my lord, now that the order has been communicated, police has come, my lord, and they said that we have to move out.
What is going on in that area, that plot?
Nothing, my lord. That is why, my lord, we are before your lordship, my lord.
Yes.
Nothing is going on, my lord. No public.
No. Who is occupying that plot?
My lord, we.
Who are you?
My lord, we are the resident of that, my lord, plot, my lord.
File and come back.
If your lordship
It's
kindly.
done pursuant an order of this court.
Yes, my lord, without making us a party to it, my lord. Without impleading us, my lord. That is the ground, my lord. One of the ground, my lord.
You've been held to be encroachers, isn't it?
My lord, 100 of people will be evicted,
Maybe.
my lord.
Maybe.
Lordship may give us an option. No, my lord, lordship may give us
File
a.
and give the number, I'll take it up. No urgency.
My lord, kindly allow us to move it 2 p.m., my
Please
lord.
file, I will not grant leave. File and give the number, I'll consider. Number to উনি দিলে সোমবারে fix করবেন. My lord, may I
I'm so
permit
grateful,
to
my lord.
mention, my lord? May I permit to mention, my lord, for file and give the number immediately. I'll fix
My
it.
lord, my lord, my lord, my lord.
My lord, for extension of interim order. Upon notice? Yes, my lord. Give the number. Give the number.
Lordship, it is one of urgent matter, your lordship. Actually, lordship has pleased to pass an order on the 16th, 19th July. That matter should be put into in a hearing list. But this matter was not taken up till date, your lordship. Actually, your lordship, that is the third party, with the help of the respondent, they are excavating the sand, your lordship. Actually, list deed is.
Mentioning upon notice?
Yes, lordship.
Give the number.
Heads up.
With that application, I mentioned your lordship, but one mistake has been done that the matter is running of your lordship Bangladesh of January 2024. That number has not been mentioned. Your lordship is allowed on that day, on 17th.
Mentioning was allowed on that day.
On that day, my lord, it is
Are you mentioning upon notice?
yes, my lord, that is
Give the number.
notice. And you know the problem is this, that is subject to the Supreme Court direction. I filed a modification application. as per the Supreme Court slip and your lordship, on that day I submit that within 31st, up to 31st, Supreme Court grants stay.
Up to 31st, within 31st, you have to file the application. That was the
Application
liberty
has
grant.
filed on 9. No. My lord, on 31st, up to 31st, there is a stay order. Thereafter, it will vacate. That's why I.
Next week, give the
My
number.
lord,
It was your mistake, sir. You didn't give the item number.
yes, sir, I mentioned the item number, my lord. Let it be on Monday, my lord.
Let me see.
I'm ready.
Let me.
Lordship, may I be permitted to mention on matter, Lordship? Lordship, it is running in the list as item number 547, Lordship. Lordship, this is second round of litigation, Lordship. On the last occasion, Lordship was pleased to direct the authorities to give a hearing to the petitioner, and if the petitioner is eligible for compensation, it should be given within 2 months. Lordship, subsequent time has been elapsed. Lordship, the hearing was concluded. The hearing was given to the petitioner. The order, Lordship.
But it has
Lordship,
not been paid.
no, Lordship.
So you file a further writ application or a
Lordship,
further
Lordship, I am filing a further writ application.
You're mentioning upon notice?
Lordship.
Give the number.
Lordship, may I be permitted to mention a matter?
Mention of interim order, my lord.
Upon
Interim,
notice?
my lord, upon notice, my lord.
Lordship may be allowed to mention a matter upon notice. The urgency is that the private respondent during the upon notice that the private respondent during the pendency had filling up the pond and causing disturbance to the petitioner. A repeated complaint had made to the authority. They are not taking any
You're
step
mentioning upon notice?
upon notice.
Give the number. Yes.
Lordship, I beg to mention that two motion I have mentioned yesterday with notice to the other side. Due to extreme urgency
Yes.
for grant of e-auction of mining lease on 27.
Yes.
And one matter appeared at item number 595 and another matter not appeared. In both the matter, my learned friend Soumitra Bandyopadhyay appearing, he was given notice. But today is 25th. Tomorrow is holiday.
কি আসেনি কেন matter অন্যটা? Where is the file?
But today, your lordship kindly in any time may be given for taking up this matter.
Where is the file?
While my lord, one matter is appear in the list, and another matter, this I have handed over the slip of two writ petitions. One appeared and another not.
One of the writ petitions is the same auction?
Same option.
Both the writ petitions?
Lordship,
Very well. So if one is taken up, we can consider.
lordship,
Let me see.
lordship.
নাম্বারটা নিয়ে নিন। হ্যাঁ, দেখি।
My lord, in any
Give
moment,
the number, please. Give the number. Let me see.
My lord, may I be permitted to mention, my lord, item number 503 of today's list. My lord, the urgency is that the illegal encroachment made which blockades the petitioner's premises which is used for commercial purpose. Your lordship passed an order on 7th November 2022 directing the petitioner to make a representation before the respondent, and thereafter a respondent was directed to dispose of the same, but respondent did not take any steps, my lord.
Are you mentioning upon notice?
Yes, my lord.
Give the number.
Great.
Lordship, may I be permitted to?
lordship, kindly, when it will be taken up.
It is
Matter
running in the
which is
list.
in the list.
Give the number. Let me see if the file comes. It is already in the list.
One matter is in the list, item number 595.
I'll call the list.
595, your lordship kindly give me time, 2 PM or 3 PM, in any
I
time.
cannot give time like
Otherwise,
that,
my
sir.
lord, today is 25th, tomorrow holiday, and 27, 10:30 is the time of auction. The lordship kindly consider, otherwise the writ will be infectious. In any time, lordship,
It is item number?
595. Mr. Bandyopadhyay appearing on behalf of this state.
595 mention matters আসেনি কেন? এটা mention হয়েছিল। When did you mention the matter? Tomorrow.
Yes, sir.
Yesterday. উনি তো মেনশন করেছেন এটা কালকে।
Lords.
And inform the other side, please.
Lords.
This is 595.
Your lordship,
Lordship, may I be permitted to mention?
Yes.
Lordship, this is with regard to item 710 of your Lordship's yesterday's list under Group 1 hearing. Your Lordship was supposed to take it up from 701. Our item was 710. Your Lordship, I am WBHDCL, the Highway Development Corporation. This is with regard to a writ filed by the petitioners in 2017. Lordship, there's been a grave urgency because this is with regard to a construction of a 6-lane joining the Kollani Expressway and the Belghoria Expressway. The project has been stalled since 2017.
Are you
Milord.
mentioning upon notice?
Yes, Milord, we have given notice, Milord. My learned junior is there before your Lordship's got with the notice. Milord, it will be, I humbly beseech your Lordship to take up the matter on Monday, Milord. Milord, because Milord takes up the matters on
hearing
Monday
matter
and
or
Wednesday.
This is a hearing matter?
Yes, Group 1 hearing.
It will appear
Your
on
Lordship
Monday,
takes
at the
that on
top.
Monday and Wednesday. Yes, I'm so grateful. Kindly give some precedence.
Monday or
So grateful.
hearing matter.
My lord, may I be permitted to mention two matters, my lord? Item number 764 and 765 of yesterday's list.
Yes.
My lord, very short point, my lord, it's covered by your lordship's order judgment, my
Are
lord.
you mentioning upon notice?
Mentioning our notice, my lord.
What is your urgency?
Well, urgency is the, my lord, the respondent has threatening my client for eviction. That's the urgency.
Give the number, please.
My lord, may I be permitted to mention, my lord, item number, my lord, upon the mentioned matter. It was mentioned before the, my lord, earlier before lordship, and the lordship was pleased to fix the matter under the heading mentioned matter. But my lord, till date it has not been taken up. Some urgency is not very short matter point involved. My lord, by an order passed by the Honorable Court, the Farakka Barrage Authority already issued the compensation award and compensation money with lying with them, but only they want a direction by the Honorable Court that what way they will disburse the money. This is the only issue.
Why there is no law to it?
Pardon, my lord?
The court's direction is necessary for disbursement.
They are saying, my lord, they have made an application that they are want a direction that in what way the money will be disbursed. Only this point, money has been released from
Are you
this.
mentioning upon notice?
My lord, earlier I have mentioned notice, Mr. Narayan Chandra Model appearing, my lord. I'll, my lord, and give another notice. Kindly fix, my lord.
Please inform him and mention once more so that it comes within the mentioned matters. It is
It is already in mentioned matter, but the
can't help because every day so much of mentioning, so it
but
has to
one month earlier, my lord, I mentioned
it will be taken up, sir. Can't help.
Lord, kindly give some people because money, my mind, money may be returned back to the.
Matters are all urgent.
Yes.
So no preference.
Well,
within the
any
mentioned
time money may be
matters.
returned to the.
I take up mentioned matters from 12:30. So please come back. Let us see. Yes.
Monday, I mentioned a matter for extension of interim order.
Yes.
It was mentioned with notice. Today also matter was directed to be taken up today for extension because the extension has been filed by extension of interim order application. Application has been filed, but file is
Let me see. Didi, passion
file is not traceable till date. I mean,
file is not traceable.
probably file could not be traceable.
No. Extension of interim order.
One matter, two matter, my lord. It was heard by lordship, my lord. The lord, party was rejected by to add a party, executive engineer, WSRDA. I have made party, and my lord, your lordship rejected to appear the matter in the same heading, that is mentioned matter. But it is not appearing, it is appearing in the Mosa.
A mentioned matter, let me tell this, it will appear only on one day under the mentioned matter
It is
heading.
not appearing. It was rejected to appear.
It's not appearing at all.
Not, it is appearing in the listed Mosa.
And that is normal. Under mentioned matter, it will appear only for on the first day. That's all.
If your
Once it
lordship
is
will
taken up
take
for
the
hearing,
mentioned matter work for one day, it will be my lord, probably.
can't help because then the mentioned matters list becomes longer.
Your lordship. Yes. So why, my lord, I have.
Added to that list.
Yes, mentioned matter added, my lord. And earlier we have mentioned matter, our matter come in the below bottom on the mentioned matter.
700 matters per day. I think sometimes it's more than that. So can't help.
If your lordship take only one day for mention.
4:30, isn't it? I cannot cross that.
Yes, that is true.
So
That is true, my lord. But it is our difficulty that we mention.
I understand, but then what can I do? I'm trying.
In my matter, my lord, money will be refunded back to the central government. That it will not never come back.
Let me see. I'll call them.
It is to appear in same heading. That is a mentioned matter. Assembly, I am mentioning.
Give the number, please.
My lord, my lord. Item number, my lord.
Please call the days list.
Item number,
Grateful, my
item
lord.
number 461 and 462.
I am for the petitioner, my lord.
Please, what correction is necessary?
Matter relating to my lord, petitioner was obtained a lease, my lord, for.
You asked for a correction. What is the correction?
No, I have not asked for any correction.
Let's apply for the Jela position.
Has to be mentioned for correction.
No, we have not.
Well,
My lord, what happened?
let me see. Number of the file has been recorded wrongly.
My lord,
For correction today.
my lord, may I submit one thing, my lord? My lord, it was appeared, my lord, as well as mentioned matter, my lord, on 8th December 2023, my lord. Thereafter, my lord, pleasure was that my matter will be taken up on 24th January 2021. That I have already served notice to all the respondents, my lord, including the state respondents, my lord. But matter was not appeared on 24th January as a mentioned matter, my lord. My lord, respondents took time, my lord.
The number was recorded wrongly.
My lord.
Correct the number. It will come again as motion.
Recording the wrong is
কবে থাকবে তাই? My lord,
এটা order। 955 হবে 9955। December 8, 2023. Paragraph in the said order, WPA 18995 of 2023 be read as 18955 of 2023. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on December 8, 2023. Paragraph, let the matter appear under the heading motion.
Well, my lord, kindly see, kindly see the position of the fees, my lord. All the
Date, sir, what are you asking for?
lordship,
And
my
today it is only for correction. I
lordship,
don't hear any.
let short date be fixed, my lord, so that my lord matter will be taken off, my lord.
1st February.
My lord, first privilege, lordship. When as my lord,
Motion.
Grateful, my lord.
motion in the top, my lord. Motion in the.
It appears, sir. All the matters are urgent. People don't come for a walk or for a stroll to court, isn't it? Next matter.
Grateful.
Date fixed, madam. Let's see. Well,
Item 2.
I beg to pay for the petitioner.
I have
The
Union of
respondent,
India.
my lord. The petitioner has challenged, my lord, notice under section 26(2) of the my lord, National Highway Control and Control of Traffic Rules, my lord.
Yeah, first.
Ground of challenge, my lord, first is that it is not in form as per Schedule 3 of my lord, the Highway Administration Rules. Second point is that my lord, I am in possession of the plot since my purchase from 2017. Before that, my predecessor in interest was in possession throughout. So there was no my lord, effective handing over of possession. So there is no vesting.
The national highways.
Served, my lord, they are not appearing.
So they are the answering respondents.
My lord, my lord.
National highways should be.
National Highway should be the answering respondent, my lord.
P4 is the relevant plot. Annexure P4 has 8 page 40.
Page 42 is the impugned notice, but before that, my lord,
Where is the service on national highways?
National Highway, page 3 at the bottom left-hand side, my lord. Page 3, bottom left-hand side, the
Miss Roy is not in court.
no, she is not.
No national highway lawyer is there.
Union.
Left-hand side, the first seal is National Highway.
But they should be the answering respondent. In their absence, how can we take?
Now, my lord, if the notice is not stayed for limited period, my lord, there is a threat of eviction, my lord. Residential building,
There is, yes.
My lord,
they came.
This is the unauthorized document.
Whether unauthorized or not, I'll show that. Notice has been given, notice is not in form. My first point is, my lord, it's a residential building. Suddenly some persons came and measured without any notice. No copy of inspection report supplied to us. Then this notice is served upon us, which is at page 42. Now, Lordship will kindly see, my lord, this notice at page 42 is not in form as provided in Schedule 3 of the, my lord, Highway Administration Rules. So this is Schedule 3, my lord, kindly see. It has to mention, my lord, the area which is in the area of encroachment, the plot number, DAG number, nothing is mentioned. So notice is defective. First point.
Schedule 3.
Schedule 3, my lord. Kindly see, this is as per Rule 11, notice for removal. Whereas I, so and so, on periodical inspection of the highway land on the information received by me, I am satisfied that an unauthorized occupation has taken place on the highway comprised of area. So this is the area of unauthorized encroachment. That is not.
Plus 430 RHs, they've
No,
stated an area.
that is not next. Area is not the area of encroachment. Area, so and so, specify the area situated at kilometer.
The area of encroachment that they've stated.
No, that is not the national highway, the area.
No. And such unauthorized occupation. So this such on it is the area.
Occupation has
of
taken place
unauthorized occupation.
on highway comprised of area blank situated at kilometer blank. So they have mentioned the kilometer. What they have mentioned here is the kilometer. But the area of because suppose whether I am
technical, so please come on merits. This is technical, absolutely.
No, unless the area is mentioned, how much is encroached? I have a residential house there. Whether 1 square feet or 10 square feet, that has to be mentioned.
How do you substantiate your title?
My title, my lord. But I have purchased the property. My title deed is at page 19, and my name was recorded in the LR record of right, page 37.
Have you filed a representation?
Representation, I have filed under section 23(3). I have filed.
In terms of this notice?
No, because I challenge the notice on the ground that it is vague. It is no inspection notice has been given to me. So it is not in violation of natural justice. And there is no title of the national highway or the central government because the land throughout is in my possession. There is no vesting. As per the provisions of the.
You have stated all this before the authority and not before this.
I have stated, Lord, kindly
will not be stated. Please let the national
kindly take up kindly take up section 23(3) of the 23 of the Act, my lord. I have a remedy under the statute. I have availed that. They have not acted upon that. Kindly see take section 23 of the my lord National Highway Control Act. There is a procedure prescribed in the statute itself. Section 23. I have made a representation under that. If I make, they have to give us a hearing. I'll just place it. Kindly come to section 23. Highway land to be deemed as property of central government. Now, my lord, kindly come to 23. My lordship has got it? 23(3). I am reading, my lord. Any person claiming against the ownership of the central government referred to in subsection 2 shall make written complaint to the highway administration and prove his claim before it, and the highway administration, after considering the evidence produced by such person, may correct such records or reject the claim. I have not made a representation.
Where is this application?
That is, my lord, at page 47. I have made under 23(3). And the record of right still is in my name. I am paying the taxes. So there is no vesting as per the provisions of the Land Acquisition Act. Your lordship, judgment of the, your lordship recently has held that paper possession will not do. In the case of Bardhaman Development Authority,
this complaint has not been considered.
They have not considered this. I have challenged their title, so they have to call us for a hearing, and I'll be allowed to.
So let this complaint be considered
Milord,
as
yes.
authority.
Yes,
And
Milord.
till disposal, there will be a stay of this.
Milord, respondent and 5, Milord, will hear all the Milord grievances of my learned friend and will.
The project director.
Yes.
Let this complaint be without wasting further time, and till consideration, this will be stayed. Yes.
And only one submission, lordship, can record your lordship held recently in the Bardhaman Development Authority matter that if paper possession will not do. If there has to be a vesting.
I'm going to merits at the moment. Let them decide. Because otherwise, I have to call for the National Highways and then give a hearing.
My lord, let them give us a hearing on 23.
Without wasting time.
Yes.
Affidavit of service. None appears for the National Highways Authority of India despite service. Paragraph 4. Paragraph. The notice issued by the
Respondent number 5.
Yeah, on the 23.
Signature of highway administration or who is the project director?
5 is
The notice issued by the 5th respondent.
Project director, my lord.
comma, the project director, National Highways Authority of India, on 1st January 2024 is assailed in the writ petition. 1st January আগে করুন। Under section 26 within bracket 2 of the control of national highways within bracket land and traffic bracket closed act comma 2002 issued on author is assailed in the writ petition. The counsel for the petitioner submits that the plot in question was purchased by the petitioner.
By the petitioner in
Purchased by the
2007.
petitioner who is in possession of the same. Stop. The record of rights is also in the name of the petitioner. Stop. Pursuant to the notice impugned, comma, the petitioner submitted a written complaint under section 23 within bracket 3 of the Act of 2002 before the authority, which is yet authority on 17 January 2024, which is yet to be considered. Stop. The petitioner seeks a direction upon the authority to consider the said written complaint prior to implementation of the notice issued on 1st January 2024. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, paragraph comma, this court is inclined to hold that since a written complaint submitted by the petitioner under section 23 within bracket 3 of the Act of 2002 is pending before the authority, comma, the concerned authority, comma, being the fifth respondent herein, comma, be directed to consider and dispose of the said written complaint within 1 month.
Within 1 month.
Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph. The order impugned, dated 1st January 2024, be stayed till disposal of the complaint dated 17th January 2024.
Some more time, Lord, of communication. They will have to communicate to me and some more time because if they go against us, not much
Dispose of
sufficient.
করলাম, ওখানে একটা line করুন, the decision taken by the authority shall be communicated to the petitioner within a week thereof. ওটার আগে, হ্যাঁ, তারপরে the order impugned, যেটা বললাম, shall be stayed till 2 weeks after communication, till 1 week after communication.
After 1 week.
Till 1 week after communication of the order.
My lord. I shall take up all my points there, my lord. Deeply obliged.
That saves time.
My lord.
You go directly before the authority.
Because I'll be relying on your lordship's judgment that no vesting has taken place because possession was never taken. Fine, I'll place it before the authorities, my lord, because
Good.
Next. Chandra নেবে না। Next.
my lord, report is not supposed to be filed by Assam for the state, my lord. They have taken, inspection was conducted, but I don't find that the report has been handed over to me. There's some substantial time has passed, but as a fault on the part of the authority.
Taken several attempts.
I know, my lord. So at the outset,
One thing I want to
I'm
indicate,
surrendering, my lord,
my lord.
kindly, I told my lad friend also, kindly, give me some time, I'll contact the officer, the PWD, my lord, executive engineer is to file the report. Initially, the BLRO has filed the report. Your lordship, my lord, added the engineer and directed him to file the report. Inspection has taken place, my lord, as informed by Mr. Rai. Kindly give me some time, I'll contact him and I'll summon all the papers.
Long back, I don't know. One thing, my lord, I want to indicate, my lord, in WP number 12668, Mr. Shengupta was appearing, whether Mr. Banerjee can be.
Serve a fresh notice.
No.
Mr. Banerjee has to be appointed.
My lord.
Yes,
Otherwise, he can.
that's why I have indicated
That is
because
the appointment, so many things have taken place, your lordship knows.
It will not be a regular appointment. That's right.
I'll copy it down.
দিতে হবে।
Please, inform the GP's
Yes.
office in the meantime.
Along with this order, so I can.
Yes.
এটা একটা ইমেইলে যোগাযোগ করতে হবে।
Learned counsel for the state respondents seeks further accommodation to submit the report in the form of affidavit as sought. Paragraph. As a last chance, the prayer is allowed. Paragraph. Let the matter appear under the same Inquiry is complete, so only the report.
Inquiry, my lord, long, at present, my lord, because it is the March 2023, the order passed by your lordship. তারপর মনে হয় হয়েছিল না?
তারপরে দুবার ইনকোয়ারি হয়েছে।
Twice it's taken place, so
সেকেন্ড টাইম হয়েছে 3 মাস আগে।
I'll contact him and I'll get all the papers.
Inquiry was
12th February should be sufficient. Otherwise, he'll come before the
because
court and explain.
once explained.
One more.
Once initially, my lord, the BLR came and explained.
So now it is not the BLR, the engineer has
No, no, now my lord, the engineer. That's
a week's more time, instead of 12 minutes. Because
So what the.
so that is what informed by Mr. Rai's junior. It must have taken
Very well, 16th,
16. No.
but no marks
I'll
on
call.
that date,
No.
16th February.
Much obliged, ma'am.
Huh?
Item 5. Display লোড কাজ করছে তো? Display লোড কাজ না করলে বলবেন, তাহলে আমি কল করবো না। বাইরেরটা। The display board is functioning outside.
No, not working, my lord. এই জাস্ট দেখে এলাম, my lord. আমার মাঝখানে হচ্ছিল,
প্রথমে হচ্ছিল,
এখন হচ্ছে, এই আগে হচ্ছিল।
আগে হচ্ছিল।
Are all the parties here, the Jila Parishad?
Yes, my lord.
জেলা পরিষদ myself, my lord,
He
myself.
has filed a report, my lord. I am
Sir,
filing
that
the
is-
exception to the report.
Mr. Bandyopadhyay is for
Yes,
this,
my
Mr.
lord.
Bandyopadhyay is not
Mr.
there.
Bandyopadhyay is leading me.
You are there? Yes. Yes.
Only one thing, my lord has directed me that land of the used as road, land of the petitioner, my lord directed me whether compensation can be awarded or not. My lord, give me, my lord, may pay for further more time for a month, my lord, regarding whether compensation can be paid or it is possible for us.
Either pay compensation or demolish. You have two
Anything.
options.
I have two options, my lord, that I have reported. Give me some time, my
Want to take instructions.
lord. Only this is the second time I am praying, my lord. I have to pay, otherwise demolish, because the public road I have to demolish. If there is no scope for any compensation, we have to demolish.
Either pay or demolish.
Again, we have to give notice, again, we have to start the process.
So please come back.
Yes, I will, my lord, I will come, so far as the only 1 month time may be given to me. This is the last time.
Please,
My lord,
come back.
from 2019.
I understand. Let him
Wha-
come back. Let him come.
Madam, I have filed the exception, my lord, to that report, my lord, that will
Exception
kept with the record.
by the petitioner to the report submitted on behalf of the Birbhum Jila Parishad is taken on record. Paragraph. Learned counsel for the Jila Parishad seeks to take further instructions
My lord, as a last time.
in terms of the
This
order
is last
passed
chance.
by this court on 19th December
আরে
2020.
দিতে পারলে তো আমরাই ভালো লাগে।
Paragraph, let the matter appear under the same heading on 26th February.
মানে
Next.
or
Item 6.
Lordship, can you remember that matter? Unauthorized construction. Item number 6, I am for the petitioner. My learned senior friend is for the petitioner.
Howrah. I am appearing for on with the Howrah Jila Parishad. Yes. Choice.
Lord, in my writ petition, an order passed by the authority is under challenge. Order passed by the district engineer is under challenge.
Challenge demolition order.
Yes.
And that is the second writ petition, isn't it?
That's item number 6. 7-6 implementation of that order.
Oh, 7-6 implementation. Right.
Seven
Second writ petition is.
Oh, I'm sorry. I'm sorry. 6
Learned
is
senior
6 is their writ petition. The
6
implementation.
is our.
The other way around.
7 is my writ petition.
So 6, I don't think you have much to submit. You are seeking implementation.
Item number 6, you have challenged, my learned senior friend have challenged the demolition order.
7.
Item number 7.
Next, yes.
Challenge an order was passed in pursuant to order passed by this honorable court. Inspection was done, hearing was given, and it was found that there was gross violation of the building rules. And the authorities have directed demolition. my learned senior friend was trying to demonstrate that the authorities have no power to issue demolition order.
My lord, will kindly have a look at page 31 first.
Of your writ petition?
Of my writ petition being WP item number 7, 1688 of 2019.
Page 31?
Page 31. That's the order impugned.
Yes.
In obedience of the solemn order dated 4/9/18 passed by the Honorable Justice so-and-so in WP number so-and-so on behalf of this Parishad, District Engineer sent notice to Sri Taposh Pal, Sri Sanjay Pal and Sri Shibu Pal, the respondents of the above writ petition, and Sri Kollan Ghosh, petitioner of the above referred writ petition, requesting them to present at the District Engineer office at 3 p.m. on 4/12/18 for hearing. The said parties present on that date. In the hearing, advocate appearing for Kollan Ghosh stated that the respondents of the writ petitioner, without leaving any space, according to building rules of Howrah Jila Parishad, constructing one building. And in the hearing, the learned advocate prayed that Parishad should take appropriate steps after inquiry whether the building constructed by the respondents are in accordance with the building rules and bylaws of Howrah Jila Parishad. But this is so not insofar as the hearing of 4th December 2018 is concerned. In the hearing, advocate so-and-so on behalf of the respondent stated that his client constructing the building according to building rules and bylaws of the Howrah Jila Parishad, and his clients have not encroached any part of property of the writ petitioner. In the meantime, as per direction of district engineer, sub-assistant engineer inspected the local on 30/11/2018 and taken note of the construction of building of the respondents. Sub-assistant engineer already submitted report with sketch map. On perusal of the report and sketch map of sub-assistant engineer, it appears that the private respondents already constructed building up to part of 5th floor. The said part of 5th floor is beyond the sanctioned plan. So that's the first observation. It appears from the report of sub-assistant engineer, the respondents already constructed structure without following the sanctioned building plan, and they extended the structure at its rear side on an average 2.1 meter. It also appears from the said report, the south side of the building is extended to 0.300 meters. In considering the statement of the petitioner and the respondents and the report of the sub-assistant engineer, it appears to me that the respondents of the writ petitioner, namely so-and-so, have constructed the building unauthorizedly and deviated the sanctioned building plan of the Howrah Jila Parishad, and therefore Sri Pal is directed to demolish or remove the deviated portion of the building within 30 days at their own cost from the date of receipt of this order. Now, the principal objection taken in the writ petition was twofold. Number one, since it refers to a report and sketch map, both of them had not been submitted to me for making a response thereto. Therefore, this is in violation of the materials relied upon in the inquiry. Now, my lord, when the report is directed to be filed, they disclose the sketch map and the report. Please have a look not to the report and the sketch, the sketch map in the report. It's a one-page report having enclosures.
That page?
Not the first page, not it says not please see the first page of the report. Not when the authorities submit the report pursuant to your lordship's order.
Give me a minute, please.
This was a G+4 storied, part commercial and part residential building. Please see, was sanctioned by District Engineer Howrah Jila Parishad in the name of Taposh Pal and others. Vide memo dated 1/2/20. I'm sorry.
So this is the one.
No, it should be a one page.
This is only the sketch map. Didi, দেখুন তো রিপোর্টটা জেলা পরিষদের রিপোর্ট map along with a photograph.
There is a very thin report of this nature. The first, it's a one-page report, and thereafter it is all enclosure.
Exception.
The
exception to the report.
Report begins with the words, "This report is submitted as per direction."
Yes.
Your Lordship has got that. Note, kindly take note the second paragraph of that report.
Yes.
The very first page. The case was started with writ petition number so and so of 2018. This writ petition was for an allegation of deviation of the sanctioned plan and unauthorized construction beyond the sanctioned plan made by Taposh Pal and others. This G+4 storied part commercial and part residential building plan was sanctioned by district engineer by memo number so and so dated 1/2/2016. Not this date is very important. The private respondents extended their structure and also made a part of unauthorized construction on the roof beyond the sanctioned plan. After placing the report to district engineer, both parties were given the opportunity through the hearing to consider their submissions. Since all the parties' submissions and based on the inspection report, district engineer passed an order to demolish the deviated unauthorized part of the said building structure at their own cost within 1 month of 7/12/2018. Please see now the enclosure. Without complying the order of the district engineer, the private respondents filed a writ petition against the order, alleging that the district engineer has no authority to pass such an order. The second page. Now the petitioner of that case has further filed a petition for non-complying the order. Then these are the enclosures. Inspection report of sub-assistant engineer with the sketch, hearing notice, copy of attendance and minutes of the hearing, copy of the order of district engineer in connection with the writ petition. Please turn over to not the first annexure, the report.
This is the order.
Not the third page of that report is the report. It begins, it has the caption of report.
This is the order that you read on the page 31 order. This is the same thing.
Yes, no, it could be the same. No, this is signed by the engineer, not the
district engineer. What you read just now is signed by the assistant engineer, the report. But after the annexures are by the district engineer. The order impugned sketch.
The order impugned is district engineer, but not this document is signed by the sub-assistant engineer. The report. The report of the sub-assistant engineer is relied upon by the district engineer. So the impugned order is passed by the district engineer, relying upon the sub-assistant engineer's report.
Where is that report? That is not part of this report.
It to
Not part of this report. This report has not been filed at all. This is not part of the brief.
No, not part of the report. But we have filed an exception to this.
This sketch map is also not there. Yes, madam, where are these documents? দিদি রিপোর্টটা ওনাকে দিন তো কোথাও পাই
অর্ডার আছে হতে পারে
The sketch map is also different from that of what you are showing.
আমাকে তুমি কিছু করে দিস তুমি বলেছো ঠিক আছে আমি দেখে নেবো করে নেবো
স্কেচ ম্যাপ তো আছেই, ওটার সঙ্গে রিপোর্টের সঙ্গে তো ইনক্লুজড আছেই। ওটা তো পার্ট অফ দ্য রিপোর্ট, ওটা তো ইনক্লোজ, কিন্তু এই রিপোর্টটাই তো নেই কোর্টের রেকর্ডে। এই রিপোর্টটা পাচ্ছেন না।
এটা তো রিপোর্টটা থার্ড পাতা। এটা তো আছে।
আপনার এটা দিয়ে তাহলে ট্যালি করবে।
এটা তো অ্যাসেসমেন্টের ফরওয়ার্ডিংটা। এটা ফরওয়ার্ডিংটা রিপোর্টের। এটা ফাইলে আছে নিশ্চয়ই। স্যার এটা তো আছে। এটা the report. ফাইল দেখে দিন ওনাকে।
আপনাদের কি কপি দিয়েছেন না আপনাদের রিপোর্ট? না, এটা তো ওরা আমাকে সার্ভিস করেছে, এটা তো এক্সেপশনও ফাইল করেছি আমি।
এটা খুলে দিয়ে দিন ওনাকে, ফাইলটা যে রিপোর্টটা উনি দিয়েছেন, রিপোর্টটা খুলে দিয়ে দিন।
স্কেচ ম্যাপ গুলো
আছে তো, স্কেচ ম্যাপ আছে তো।
তাহলে ওটা ওটা ওখানেই আছে ফাইল।
ওটা এক্সেপশনটা, ওটা থাক, ওটা না। রিপোর্টটা যেটা আপনি আমাকে বের করে দিলেন। উনাকে দেখান কোথায়? You manage the order instead. This is the report submitted by you. Please check. কপিটা ওনাকে ফেরত দিন। ওনার কপি।
Yes, yes, this is the one I'm referring to.
The order. This is not the sub-assistant engineer's report. You're referring to a report submitted by the sub-assistant engineer. That is not part of this report.
এইগুলো সব আছে।
এটা পুরোটা নেই তো।
এই তো আছে দাদা, এটা আছে।
আরে সবটা নেই, তুমি দেখছো না?
হ্যাঁ, এই
এটা এটার সঙ্গে মিলছে।
এটা মিললো।
তাহলে তারপরটা কোথায়? নেই, ইনকমপ্লিট।
Yes.
ইনকমপ্লিট, দিস ইজ
এইটা নয়, না এই রিপোর্টটা আপনাদের 7th March 2022 রিপোর্ট। এই তো যেটা পুরোটা।
হ্যাঁ, যেটা ফাইল করেছেন তাতে সব অ্যানেক্সচার গুলো নেই।
It's only fine. He's given another copy of the impugned order actually.
এই রিপোর্টের অনেকগুলো অ্যানেক্সচার রয়েছে।
Where is the other copy? Wait, give me a copy, please.
আমরা দিয়েছি।
এই যে এক্ষুনি দিলাম।
এটা my order copy তো? Again, why fixed on Monday? Do you have a spare copy? Mr. Williams?
Yes, yes, continue.
Yes, continue.
Lord, I was placing the annexure to the report.
Yes.
Lord, this has a heading, report, and at the bottom it is signed by the sub-assistant engineer. In connection with the above reference writ petition number so and so, it is hereby reported that the private respondents got sanctioned a G+4 residential flat building structure. But the first observation was it's a residential commercial building. The sub-assistant engineer proceeds on the basis that it's a residential building. From this Porishad comprising RS Dag number so and so, reference at Mouja Bali under Shapuipada so and so, as per order of the Honorable Justice 4/9/2018 for that writ, an inspection was held by undersigned. At the time of inspection, it was appeared that the private respondent had already constructed the building up to 5th floor, one extra floor partly beyond the sanction plan. They constructed the structure without following the sanctioned building plan. They extended the structure at its rear clearance area which should be 3 meters as per sanction, but it was found minimum 0.895 to maximum 1.185 meters. They shifted the RCC columns at rear side for 1.63 meters. As a result, the total building width area lies at rear clearance zone, which is unauthorized. The boundary line presently remains same as appeared at the time of inspection for this sanction. The south side of the building also deviated from the sanction line by 300 millimeters approximately, and front side was extended to 0.945 meters. The detailed deviated unauthorized portion of the structure and its reference sanction plan and present image of that under constructed structure are attached herewith. So, this is revealed for the first time before this honorable court. So, when the hearing officer passed the order, I did not have an opportunity to contradict this. I'll show to your lordship the minutes of the meeting. So, this is the sketch map. I am not taking your lordship. It's 0. Some millimeters here and there, and 0.895 meters there.
Above the staircase.
Yes, not above the staircase, there is a hatched portion. Kindly takes not the note sheet of the sub-assistant engineer in Bengali.
Yes.
But it records the attendance of the persons. Everybody is present. উপরোক্ত সভায় কল্যাণ ঘোষের সরকার so and so জায়গায় অ্যাডভোকেট বক্তব্য রাখেন যে these are the submissions recorded. But whatever is there in the page is his submission recorded.
Yes.
Then kindly turns over the page to Taposh Pal's contention. The second paragraph is contention for Taposh Pal.
Yes.
Third paragraph is contention of Kullan Ghosh. Then joint inspection, so at the time of inspection, no measurement is made and only the submissions are recorded. Nowhere does this note sheet will reveal that in presence of the parties this measurement was done.
But certain measurements are stated in the report.
In the report. When I submit that the proceeding suffers from gross violation of natural justice and this report vis-a-vis the inspection note, this does not conform to the requirement of law.
The dispute is with regard to the fifth story.
No, that is a hatched, that's not a pakka structure, that's a hatched construction on the Chilekotha. That's the attic, on the attic.
Have you applied for regularization?
Yes, there is a provision for. But
provision, have you applied?
আমার একটা representation আছে তো। No, I don't think so. There is a representation. Now, I'm not. Kindly take section 160 capital A of the Act, of the Panchayat Act.
Do you have a spare book?
Yes, fine.
With mark, my little bit.
Yes.
Please see note the date on which this section was incorporated, 9/11/2017.
160.
160A, capital A. And I believe that this will be handy for your lordship. That
পরের পাতায় ওখানে দেওয়া আছে। তলায় inserted by
Annotated.
both.
তাহলে তো এটা একটু দিন জাস্ট নিচের লর্ডশিপ কাইন্ডলি এক্সকিউজ দেওয়ার মার্ক।
Yes. 9/11/2017.
Yes.
Yes.
Section 160A inserted by Section 8 of the West Bengal Panchayat Amendment Act 2017 with effect from 9/11/2017. No person shall erect any new structure or new building or make any addition to any structure or building having plinth area of more than 300 square meters and height more than 6.5 meters in any area other than an area of an industrial estate or industrial park within the jurisdiction of any panchayat under the area of a Zila Parishad, except with previous permission in writing of the Zila Parishad. So, not certain areas and height are mentioned for the purpose of previous permission of Zila Parishad with a restrictive covenant that with regard to erection, but this will apply only on and from 16/11/2017. Kindly recollect the date in the impugned order of the district engineer, which specifically mentions that the plan was sanctioned sometimes in 2016. 25th of January 2016. So primarily, not the provisions of 160A will not apply.
Page 20.
There is the date of the.
Yes,
plan
that
being
2016 date is at page.
Page 20. Sanction.
আরে date of the sanctionটা কোন অর্ডারে জানতে সেটা চাইছি। I just read it. It is আরে এক্ষুনি পড়লাম কোথায় গেল কোনো না চট করে
রিপোর্টের রিপোর্ট চাই ফিফথ লাইন রিপোর্টটা পড়লে তো ফিফথ লাইন
First February 2016.
Yes, 1st February 2016. Not the first page of the report, 1st February 2016. Now coming back to that section 168. Provided that where the state government or any authority or not urgency, I am not on that. Not the second proviso is also not applicable in my case. Provided further that such erection of new structure or new building or such addition to any structure or building or such permission of the Zila Parishad shall be subject to such rules as may be made by the state government in this.
But you referred to 160A.
Not I find this is the only enabling provision for Zila Parishad to take action.
So prior to effect of 160A, any unauthorized.
Not 160, this is an insertion. This is an insertion. Now 160, 160, not that's vesting of power in the, could be the panchayat.
But prior to 2017.
Yes.
Any addition alteration was permitted without permission? That cannot be.
No, cannot be. Not, please take note section 153. No, it's only not control of powers of Zila Parishad, not the authority vested with the panchayat or not Samiti, whatever might be.
section 23(6) was
That was there. Section 23 was power of the panchayat. It was power of the panchayat.
Even before this insertion, that was
23(1)(5) of the old act. Similar provisions in the new act, 23(1) and 5.
This is panchayat.
Yes.
this is panchayat.
But the present construction is under the Jila Parishad, not the panchayat.
No, my lord, I tell you, under the act, when building is above a particular height, the panchayat authorities will send the thing for vetting to the Jila Parishad. The construction within a panchayat area comes within section 23 of the Panchayat Act.
Yes.
When there is a building which is a multi-storied building, that ought to be sent to the Jila Parishad for vetting. because these days in panchayat areas also multi-story buildings were coming up. And as because the panchayat authorities they do not have that requisite infrastructure, that's why it's being sent to Jela Parishad for vetting.
So even if Mr. Mojumdar, you say that 160 capital A is not applicable, prima facie, 23 is applicable.
23 is applicable. Not, when I submit that, not is the question of authority and jurisdiction. Not your lordship, I believe, not has been pleased to put this question to the parties. What is the authority and jurisdiction? Apropos this submission, not when a plan is sanctioned before 2017, the provisions of 160A will not apply. 160A comes under the chapter where the Jila Parishad is conferred with specific powers. It commences from section 153 onwards. But it has a chapter heading, Powers, Functions and Duties of Jila Parishad. So all these regulatory provisions in 160A can only have a prospective effect and not a retrospective effect. Now, when it comes to control of building operations, please see,
Yes, yes. That is 160A.
yes, kindly text note 160A3.
Yes.
Not one has to apply for sanction of a building plan to the Jila Parishad. Then kindly text 160A3. On receipt of such application, the Jila Parishad, after making such inquiry and examination of the building plan as it considers necessary and in accordance with such rules as may be made by the state government in this behalf, the additional executive officer of the Jila Parishad shall issue formal permission in writing or refuse it, recording in the case of refusal the reasons therefor, with the prior approval of the executive officer of the Jila Parishad. So even in such cases, the sanctioning authority is somebody else. Provided that for construction of a structure or building having height of more than 15 meters, the Jila Parishad concerned shall send the building plan and the site plan to the panchayats and rural development department, which shall place the building plan and the site plan before a building committee to be constituted by the state government.
Applicable here.
Then 5, any person aggrieved by an order of the Jila Parishad refusing permission on non-receipt of an application, intimation. Then 6, where any new structure or new building or any addition to any structure or building is being or has been erected or made, as the case may be, in contravention of the provision of subsection 1, the matter shall be heard by a hearing officer who shall preferably be a retired senior government officer with the experience of having worked as a magistrate and shall be appointed in the Jila Parishad by the state government. The hearing officer shall, after giving the owner of such building an opportunity of being heard, submit his recommendation to the executive officer of the Jila Parishad. The executive officer of Jila Parishad shall take decision for demolition of the building or a portion of the building, as the case may be, by the owner within such period as may be specified in order, and in default, issue direction to the subdivisional officer concerned. So not out and out. The divisional engineer's exercise of jurisdiction is beyond the sanction of law.
But this again, according to you, is not applicable in your case.
Not, I take it against my client's interest. Today, if 160A is brought into play, 160A has to be enforced with all provisions. Either Jila Parishad retains jurisdiction or it does not retain jurisdiction. If it retains jurisdiction, then this jurisdiction has to be exercised in the manner as is permissible in law. And such jurisdiction is vested only in executive authority.
Yes. Yes.
Now, this is apart from the fact this order suffers from gross procedural irregularity and illegality. That first of all, it's only submission recorded during inspection, no measurement carried out. For the first time before this honorable court, I come to know that a sketch map is prepared. That report and sketch map is not handed over to me during the course of hearing. But if this could have been handed over to me, I could have said this is only 0.33 millimeters or 125 millimeters, centimeters here and there. I could have applied for regularization. It is provision for regularization. Please see his writ petition, page 26. Yes.
That's why I asked whether you have.
No, this was disclosed for the first time before this court. And that's why I took your lordship through the entire office note prepared, the field inspection report I placed before your lordship at the behest of the assistant, sub-assistant engineer.
Let the Jila Parishad respond to this.
Lord, may I take a short leave, Lord? Short leave, Lord, I shall come.
What is the provision under which you have passed this order?
Notified area, KMJ notified area. Jila Parishad has got the power to pass it. According to Town and Country Planning Act. According to Town and Country Planning Act. I have showed it. So far my knowledge goes, I have showed it.
On the last petition, they
day,
have
last
also
topic
relied
has-
upon 160A, my lord. When my learned friend
Not
made
only,
made
not
a
only
submission,
168,
my lord.
I have showed Millard.
60A prima facie is not applicable
Yes.
in this case.
But with regard to the submission made by my learned senior friend,
Yes.
but I tell your lordship, this exercise is being done in pursuant an order passed by this honorable court. A coordinate judge of this honorable court have directed, and he directed the Jila Parishad. That order has not been challenged. And now, when that order is staring at everybody's face, we cannot say,
Where is that?
"But your lordship says page 33 of my writ petition, page 33 of my writ petition, WPA 2556 of 2019.
Well, that order is also annexed here, man. Kindly have a look at.
Yeah, I've got that.
Your lordship says, may I just place the order?
This
The
is non-consideration of the application by
My
the
lord,
Jila.
I tell your lordship, the grievance of the petitioner in the instant writ petition is non-consideration of the application complaint filed by the district engineer, Howrah Jila Parishad on 3rd August. According to the petitioner, there are prescribed rules and skipping on is maintained in constructing building having more than 2-storied and or height up to 15 meters. The petitioners, this court, next page, page number 34, this court therefore directs the Howrah Jila Parishad to consider the said application complaint dated 3rd August 2018 filed by the petitioner and dispose of the same within 4 weeks from the date of communication of this order after affording an opportunity of hearing to all interested persons in accordance with law. This order was passed in presence of my learned friends. This order has not been challenged. In pursuant to this order, the authorities of Jila Parishad have inspected. In the time of inspection, my learned friends' clients were there. In courts of hearing, they were there.
The court said nothing on merits.
My lord.
The court.
He directs the Jila Parishad.
The petitioner comes up before the court and says, I filed a representation for unauthorized construction which has not been considered. The court says, consider the same. Right? Nothing more. The Jila Parishad is the person who is aware as to who will deal with the application and who will pass an order of demolition. Number one. Number two, if the Jila Parishad relies on 160, there should be some provision for demolition. I would like to know what is that provision.
Section 23.
Because 160A is not really applicable.
But if I
take council says Town and Country Planning Act, section 53.
Yes, Millard.
That bestows power upon the Jila Parishad in case of notified areas.
Notified area.
And this particular area is a notified
Notified
area.
Do you have the town and
My lord,
Shantanu?
the main crux of the matter, my learned friend is not saying that it is not unauthorized.
No, no. He says there are slight deviations.
I say, my lord, that I say there are major deviation because the measurements also which has been considered, they have considered my land to take the measurement.
Measurement ought to have been taken in presence of both the
My
parties.
lord, we were there. I'm not taking my lord. There was deviation.
Was the
Now,
correspondence there when the measurement was taken?
yes, my lord. Your lordship, my learned senior friend, have relied on the report, inspection report, and it is not that case that they were not there.
They say that the report and the measurement was not given to them at the time of.
My lord, they could have, with greatest humility, they could have asked for it at the time of hearing, because they were present in the time of at the time of hearing.
All the parties were present, Millard. At the time of inspection, all the parties were present.
Section 53 also talks about a notice to be issued
country planning.
prior to hearing. Was this notice issued?
Notice were issued, my lord. They were there at the time of hearing.
Apply notified
They were there. My lord, the hearing was my lord, I don't know whether my learned friend have made any representation for regularization,
Has not.
whether that has been considered. He have other reliefs, my lord. But in particular with this allegation of unauthorized construction, the authorities, my lord, sat tight over the matter. In spite of direction and in spite of direction for demolition.
Present ছিলাম ইন্সপেকশনের সময় হিয়ারিং এও প্রেজেন্ট ছিলাম ইন্সপেকশনের সময় আমরা প্রেজেন্ট ছিলাম
ইন্সপেকশন তো মেজারমেন্ট আছে
আমরা রিপোর্ট চাই হিয়ারিং এর সময় এই কথাই বলেছেন কিছু
When considering submission of my learned senior friend, if this order goes and my lord, fresh inspection is being done, my lord, what will happen? Unauthorized would be there, my lord. It's not a case that unauthorized can be regularized, even if this order is set aside by your lordship.
It's done in presence of both the parties.
That's why I did that handwritten minutes. No measurement done. It's only the submission recorded.
And that submission for hearing, which my learned
The handwritten note.
hearing at the time of hearing,
No, that's the spot inspection.
hearing.
field এই যে field
That's field inspection.
no file লিখেছে attendance of
hearing. এটা উনি করলেন hearing. ওটা দেখুন ওটা hearing.
No, this is attendance and minutes of hearing.
Hearing.
Not the
That is
inspection.
submission for hearing. এটা তো মিটিং এ ছিল।
That is the 4th December, right?
A sketch map has been prepared, so it can be inferred that there was some measurement done.
But that I have
Right
come to
or,
your lordship.
right or wrong, I mean, there was some measurement
There
done
has to be, since
on
the
the spot.
sketch map was produced before the hearing officer by the
in
sub-assistant
presence of
engineer.
both the parties.
Sir, that's not revealable. That's not revealable. You might have, please see read the order once again. Page 30, 31.
Are you asking for a reconsideration after
Why
going
not?
through these?
I can not, if it is a minor, as it appears, it's a very minor deviation. Somewhere it's 0.33 millimeters, somewhere it's 0.2 meters. I can always apply for
Counsel says it's
regularization.
major, you say minor, so let the authority decide.
Yes, yes. Not kindly furnish me, I have kindly grants me some time, I shall make a representation for regularization of it. Let them consider.
That you can do that. That why court sleeve is
So
zero.
0.300 millimeter, 0.300 meters at one place. The other it says one, somewhere it says millimeter.
30 m
0.300 meter.
হ্যাঁ মানে মিলিমিটারই আসছে
In the backside, it has been encroached
Clearly,
up to.
clearly shows that the building area has not gone beyond the boundary.
Which should be 3.0 meters, it has been extended to 0.895.
Yes.
Well, the entire area has
No,
been
it was
encroached.
found minimum, there ought to be a vacant place of 3 meters. Instead, there is a vacant place of 0.895 meters to maximum
Less than
1.185 meters. So, not there, it's possible that there is a
Instead of 3.
instead of 3
It's less than 1. 8.9 or less than 1.
to 1.185 meters.
Yes, this is less than 1 and the other,
Kindly see my
There is 300 millimeters approximate deviation.
kindly
The second last line of that page.
300 and
Report of district
0.98945 meters.
Yes.
kindly see a report of district engineer, my lord.
Yes.
Paragraph 3, on perusal of the upon show and showed the said part of fifth floor beyond the sanction plan.
Where are you
Fifth
reading?
floor is totally unauthorized.
No, fifth floor is not constructed. It's a hatched. Please see the sketch map. Please see the hand sketch map. It's a hatched line or portion unauthorized. It's only a hatched line or portion, not the entire one.
Here
But report says so. Fifth floor is totally unauthorized.
No, I am showing the hand sketch map of the authorized officer. The drawing,
page number 4 of the report.
page number 4 of the report.
Yes, the order says fifth floor entirely is unauthorized.
Yes.
But the report of the sub-assistant engineer doesn't say so. On field verification, it shows deviations. There is not one line saying that the entire floor is unauthorized.
After inspection, it has been detected fifth floor is unauthorized.
After inspection, what has been detected is in the report of the sub-assistant engineer.
Sub-assistant engineer.
But on the basis of this report, the district engineer holds that the entire floor is unauthorized.
Yes.
But, I don't.
Because my lord,
the
because my lord,
reports don't tally.
because my lord, initially their building was for
G plus 4.
G
Yes.
plus 4.
Plus 4.
Fifth floor, G plus 4, fifth floor.
Fifth floor is totally
Fifth
unauthorized.
floor is
Fifth floor, no
Chatala.
No
Floor is
construction.
Chatala.
Please see not this hand sketch map. This is the part of the report. Hatched line or portion is unauthorized. Only a portion of this, which is hatched line.
There are anomalies. There are anomalies. The reports do not tally. So let there be an opportunity to given to the petitioner in the second writ petition for filing a representation to the authority. Till then, let status quo be maintained.
That is there, my lord. Your lordship kindly fix a time limit. By
Yes,
that time,
absolutely.
they will pass a reasoned order in presence of both the parties.
With clear sketch map. With clear sketch map.
With clear sketch map, we will call for another fresh inspection. Let the authority decide. Let
But
there
the
be a
thing is that, my lord, the thing is that, my lord, there was deviation. Admittedly, there was deviation, and all this period of time, there was no representation for regularization. And these days, your lordship knows law is very clear in the matter of illegal and unauthorized constructions. Without caring for them, an additional floor was done. G plus 4 additional floor was done, and that is the reason why we came before your lordship, because the Jila Parishad authorities ought to have done their work in a diligent manner.
heard learned counsels for the parties. An order passed by the district engineer, Howrah Jila Parishad on 7th December 2018 directs the writ petitioners in WPA 1688 of 2019 hereinafter referred to as the second writ petition, bracket closed, to demolish/remove the deviated portion of the building in question within a stipulated time frame. Stop. The petitioner in WPA 2556 of 2019, within bracket hereinafter referred to as the first writ petition, seeks implementation of the said order. Stop. The petitioners in the second writ petition have assailed the said order on several counts, COUNTS. Paragraph. Learned counsel for the writ petitioners in the second writ petition submits that the report of the sub-assistant engineer, Howrah Jila Parishad, on the basis of which the order impugned has been passed, does not contain proper and specific measurement of the allegedly deviated portions of the construction. Stop. Also, Section 160, capital A of the West Bengal Panchayat Act 1973, relied upon by the Jila Parishad, is not applicable in the present case, since the said provision of law came into effect on and from 9 November 2017, whereas the building plan was sanctioned in favor of the petitioners on 1st February 2016. Stop. Learned Counsel seeks liberty to submit, the petitioners seek liberty. The petitioners seek liberty to submit a representation before the concerned authority for regularization of the alleged deviations in the construction, since according to Learned Counsel, such deviations are minor and may be regularized by the authority. Paragraph. Refuting such submission, Learned Counsel appearing for the petitioner in the first writ petition submits that the entire fifth floor of the building is unauthorized, since plan was sanctioned for a G+4 building. Paragraph. Be that as it may, this court is inclined to hold that since the petitioners in the second writ petition intends to submit a comprehensive representation before the concerned authority seeking regularization of the deviations, if any, such liberty be granted to the petitioners in the interest of justice. Paragraph. The petitioners in the second writ petition are at liberty to submit a representation before the should be the executive. Who should deal with your representation? The district engineer.
Yes,
District engineer.
Yes. No. District engineer. But if we go by the provisions of the General Clauses Act in the absence of special provisions in the statute, then it should be the authority which grants the power plan and not. No. It is under the law. If the power to demolish vests with the executive officer, then it should be the executive officer.
He has not been made a party in any of the writ petitions yet.
Executive officer has been made a party. And the additional executive officer is the respondent number 4. In our writ petition.
To him.
Executive officer আছে.
Before the additional executive officer, Howrah Jilla Parishad, being the fourth respondent herein, within 1 week.
Within 2 weeks.
Within 2 weeks.
Within
2 weeks from date, the fourth respondent is directed to consider and dispose of the representation within 1 month, within 4 weeks.
What my learned friend is saying, respondent number 4, that post doesn't exist.
It's there in the statute.
District engineer, my lord.
That is the fifth.
District engineer is the
fifth respondent. Within 4 weeks, is directed to consider and dispose of the representation within 4 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioners in both the writ applications, in accordance with law. Further construction is not being made.
It is complete
No, it's a completed construction. 28
What status quo is required at the moment. Paragraph. The decision taken by the authority shall be communicated to the writ petitioners in both the petitioners in both the writ petitions within 7 days from the date of within 7 days thereof.
But may I submit this? No, it's my learned friend's contention that the district engineer is presently vested with the authority of the executive officer. Kindly have it recorded. Otherwise, it may amount to not submitting to jurisdiction of the district engineer.
যেখানে রিপ্রেজেন্টেশন দেওয়ার এটা করলাম is at liberty তার আগে একটা লাইন অ্যাড করুন learned counsel for the Howrah Jilla Parishad submits that such representation ought to be submitted before the district engineer Howrah Jilla Parishad, who is authorized to deal with the same. Liberty. Both the writ petitions being WPA দুটো disposed of. Which at length have read your books.
সাবমিশনের রেকর্ড যদি না থাকে পোস্ট কি করবে তুমি?
Item number, Mr. Ujjwala is appearing, my lord, on behalf of the petitioner, but he has a bereavement in his family, my lord. So, my lord, he is there, my lord, to attend the last rites, my lord, of his uncle, my lord. So only accommodation for the day, my lord.
But there was a stringent order passed on the earlier date. Learned counsel for the petitioner seeks accommodation due to bereavement in his family. Paragraph, let the matter appear under the same heading on 22nd February.
My lord, my lord.
Next.
My lord, item number 8 to 12, my lord, same identical matters, my lord. 8 to 12, my lord.
8 to 12, same order.
Grateful, my lord.
Next. Martin.
Your Lordship, in this matter, the matter is related to National Highway acquisition, Your Lordship. I'll just brief Your Lordship short about the matter because I have received opposition from the state and the highway as well. Initially, this land was acquired by the National Highway as per the statement in 2010. But I had received no notice of acquisition because it is admitted by the state that due to some difficulty, they are not being, because they are saying in the record of rights, my name was not there. But I have purchased this property in 2008 and I have incorporated my name in the record of rights 2009. I have the documents for that. So I have not received any notice. Initially, I received a notice that they asked me that you are illegal trespasser over there, so you are asked to remove your property. That's why I came to know that my property had been acquired. I made a representation before the concerned authority. They gave me initial 4 days of hearing. They passed an order, Your Lordship. Now, the state is saying that this, and my claim was under the 2013 Act because I received this notice in 2018 and till now I have not received the payment. Now they have given me notice to collect the payment. My grievance is, Lordship, that they should pay me in 2013 Act. They have already said in this opposition, they have given me the copy of the arbitration as well. The highway is saying the arbitration has already taken place. 4 Moja's arbitration has taken place. I was never participated. They couldn't show from the record. Initially, I used to find that for a single Moja, 1 arbitration used to take place. In this, the arbitration award says for 4 Moja, 1 arbitration award has been given. But I was never party to that. Now, the state, as per their report, they have given me a 3G1. They are saying that is the calculation sheet. Now, that has to be in Constitution 7. The ingredient should be there. I'll ask your Lordship to kindly come to that first. That is a report in form of an affidavit by the state. Page 27, Your Lordship.
The state's report.
The state's report, page 27. Because this, Your Lordship, is an NRS agro company. The state has visited, they have made joint inspection, and it's admitted that it's a factory still being run from the year 2008.
Page?
Page 27 of the state's report, Your Lordship.
Yes.
This they're saying to be a statement of award for, it's an For the mergers, your lordship will find for 3 mergers a combined statement. So how my proportionate share has been affirmed or what they've considered, nothing is reflected over there. Kindly see on the top, your lordship, there are 3 mergers. Mukundapur, Gopgram and Shivpur.
They have given an explanation under the column basis of calculation.
Yes, your lordship. But that calculation has to be for me because there is a factory over there that is their report as well. When they have made the joint inspection in 2018, they have stated that they have got one factory over there.
Why don't you approach under 3G5?
Your lordship, definitely I can approach under section 3G5. But there are 2 difficulties, your lordship. As per my understanding, subject to your lordship correction and approval from my senior friend, an arbitrator can only do the enhancement part. The new application of 2013 Act or not, that is beyond the scope of arbitration. And once I have to go for arbitration.
Arbitrators are deciding on to 2013.
But your lordship, if the Act says they can enhancement of compensation only.
Enhancement of compensation, if 2013 Act is applicable, arbitrators are dealing with it.
If your lordship,
I've seen several arbitral awards where they deal with this and they say that they are entitled under the 2013 Act.
that can be done, and kindly see one page 43, your lordship, that is the arbitration award
43 of the report?
of the report, your lordship.
Yes. So this is neither here nor there.
This is 2-page award
Award.
for 4 mergers done together.
This is like we say Gono Bibaho, this is a Gono award. Not, yes.
My lord,
Roy will have serious objection to this, yes.
no, my lord, I from that, my lord. My lord, the prayer is, my lord, to set aside the notice, my lord.
Yes,
The
because
notice, my lord.
one second.
Yes.
Once your lordship, I filed this matter, I didn't have this
My
documentation.
lord,
It
the
came through
difficulty is,
affidavit.
my lord, their submissions in a different way, my lord, their pleadings in a different way, their prayer in a different way. Here, submission, lordship, as per page 42 of annexure P2, to set aside this notice.
Notice of payment, your lordship.
No, my lord, the first notice is for the unauthorized occupations, lordship. That notice is that is the prayer 1.
Page 48.
The 12th August.
My lord.
Yes.
Page 48, your lordship.
And another notice
That
is
is the primary prayer.
Yes, your
my lord.
lordship. Why? Because
How, my lord, one hand, lordship, they receive the compensation, and other hand, lordship, they challenge, they sitting tight over their property. But it is a totally a clear doctrine of appropriate, reprobate, my lord.
Grievance with compensation will not have nothing to do with delivery of possession.
no,
We
your
will
lordship,
discuss
because
afterward.
I am challenging this because before this page 48, which is dated 18/12/2018, the state has admitted that they have not given me any notice of acquisition. At least I am entitled to know because now the state claim is that in the record of rights, my name was not there. I can produce before your lordship the record of rights, the date when I have purchased this property.
Come back with a supplementary affidavit.
Yes, I supplement that.
Since, yes.
He has not any case from the exception. It is very clear. He is, my lord, only he challenging all the 3G1 and 3G5, my lord. Stating the fact 3G7 was not that actual calculation. My lord, if your lordship will come to his exception. Entire exception, my lord, to that effect that he must find that 3G6, my lord.
Your lordship is.
Yes, the exception.
My lord, your lordship will see the exception page 3. Ask my lord, he is
Page
the owner of the land.
Yes.
Page 3, my lord, exception.
Yes, yes.
Now, my lord, now B, my lord, it is further submitted that the petitioner was not aware of the fact that his Karkhana was acquired in the national authority, as no notice was served to that said land was purchased by the petitioner. My lord, my lord, he said that, my lord, there is no permission of 3C, 3D, those provision is not too personal. And my lord, he said notice was not given to him only for that the petitioner purchased the land in the 5th March 2008. It is pertinent to mention here that one notice of illegal occupancy had been served to the petitioner by the respondent number 8 on 18. After having impugned notice, the petitioner approached before the concerned authorities after 2019 with a representative to consider the representative by setting aside the accused notice and issue payment of notice in favor of the petitioner and deposit the same to the bank account on the provision of a right to fair compensation. That my lord, that see my lord, that the report dated after filed by the respondent authority that the payment of the petition was not released just after the declaration of the award due to the non-apportionment of the amount among the co-sharers of the plot, and also submitted in the report that the competent authority prepared award under section 3G1 as well as arbitral award under section 3G5 has been passed. My lord, that is an admitted position. My lord. Now, my lord, now it is B, my lord. Now, my lord, now it is important to mention here that the concerned authority did not follow the provision of National Highways Act. The respondent authority had failed to disclose the copy of the award, which was determined by the competent authority required by section 3G1 and National Highways Act. It would be pertinent to state that till date, even after filing the instant petition, the respondent authority had never supplied copy of the award as determined by the competent authority required by the 3G1 of the National Highways Act for the respondent. It would be relevant to state that the state government had supplied statement of award. From it is clear that the competent authority had not followed section 73G7 of the National Highways Act while preparation of the said award, and hence the entire land action needs to be quashed and set aside by the judge. My lord, now my lord, E, that is as per report of the form of the evidence, it has been established in fact that the authorities has issued an arbitral award in LA case number itself a violation of 3G5 of the NH Act, and as the arbitration proceeding had been done grossly for 3 mojas without allowing your petitioner to participate in this. Whether without allowing your petitioner, why not allow that? Not was my lord clarified in the petition. My lord, he complete now my lord I will come. Now my lord, F, that is the arbitral case number is not according to the market value and date of the there is no specific individual calculation has been reflected regarding the components of 3G7 of the My lord, entire exception is completely, my lord, that the arbitration was not in accordance with the provision. That will not be challenged before the Honorable High Court. That must be challenged before the 3G6, my lord. So, my lord, the petition is not maintainable.
3G6 only when he participates in 3G5.
No, in spite of that, my lord, there is a provision of, my lord. In every case, if I am not a party of the proceeding, my lord, I can find that there is some provision.
No, Mr. Day, I'm sorry. Not in this case. 3G5, he has an opportunity of 3G5 still. Because there are several judgments, even this court has passed judgments to say that if no notice was issued upon the petitioner and he was not given an opportunity.
Was issued, that was not, my lord, his case. His case is that, my lord, he was not allowing to participate.
The language, you are
that is, my lord, language, my lord.
Your lordship, only one document I will refer.
My lord, entirely vitiated his case, my lord. He stated that.
Please show me one document, Mr. Day, that the petitioner participated in the arbitration. He is out of court.
But
his case could be on this point also, lordship.
Yes.
His case on this point only. He's only aggrieved with the quantum. But he's not aware of this. His prayer, lordship, never shows that he is only aggrieved with the copy of this award. He shows only set aside.
Came with your reports. He was not aware of the accusation at all.
So, my lord, his case, lord, he filed this application in the 2019.
Based on that,
I think it is better if you come back with a supplementary.
And only one more, your lordship. I'll annex the subsequent documents. Page 24 of the state report. Your lordship, only I'm putting this question to myself. As per section 3G1, there shouldn't be order or award, whatever it may be. I made an application before them. Kindly see page 24. They called me for a hearing and they passed an order as well. So this is 3G1 or the initial was a 3G1. Now the state has to come with that. Section, kindly see page 24. They passed an order giving me 4 days of hearing. So under what provision has the state called for hearing again? If arbitration has been completed, it has been done by the state authority. The arbitrator was the district magistrate. Now it's the Malda divisional commissioner.
This hearing is with regard to what?
Regarding my representation, now they have given an entire hearing. Now they are saying this is the hearing. Your professional share is this. So initially it was not done in 2010 or 11. They have passed this award, Your Lordship. This is not my award. This order, award, whatever it may be, they have passed in 2018 after my representation. Kindly see the date, Your Lordship. এই তো তারপর তো 3 পাতার অর্ডার দিয়ে দিয়েছো, তাহলে অ্যাওয়ার্ডটা কোনটা? আগেরটা না এটা? X24 দেখো। Now this is then they don't have any power under the law to reopen the case if arbitration is completed as per their statement. So they have passed this order in 2018 based on my representation. And it has been passed by the additional LO. So as you have followed for your lordship, I'll come with a supplementary affidavit. I'll disclose all the.
I do not find any document to show that either 3G1 was earlier served upon the petitioner or 3G5 notice was issued. And the petitioner applied for.
Yeah.
Yes.
He purchased the land after that.
No, he
Was not
purchased in
there.
2008. When was the acquisition made?
2009-10, Your Lordship.
When?
The case number shows that, Your Lordship. Always the case number is the acquisition year.
Yes, it's 9 and 10. Purchase was in 2008. So he's not a post-vesting purchaser.
Appeal under section West Bengal LR Act 19.
ওটা তো কনভার্সন করিয়েছি, ওটা জমিটা কনভার্টেড ফ্যাক্টরি করা যায় সেটার জন্য।
His name was not there in the record. That is the application, page 21, my lord, you lordship will see.
Page 21
of my
report.
My report.
না না আমার তোমার না। Of my
12 and 13, my lord, appeal case number, read which section. Case record, it appears that a common Buddha and others, my lord. And my lord, last page, that is the order, that is the page 25, my lord. Here it is hereby ordered for the change of classification of the exercise of power conferred under section 54. IB of the West Bengal permission here is giving ground marshal on the the recorded classification of non-agree.
That was regarding conversion, Your Lordship. Well, initially when I bought it, it was a Krishi land. After that I have converted. The conversion is in 2012. I'll submit the record of rights and the date of my deed, Your Lordship.
Come back with the supplementary.
I'll do.
Only,
Let the petitioner come back with the
my lord, at least, my lord, the first prayer should be not praised, my lord. His case is only with regard to the compensation, my lord.
Your Lordship,
How his lordship
Not
is.
only that, he is also challenging this because since he has not received notice.
I have not received notice and notice payment. I have not received the compensation till date, Your Lordship.
Then, my lord.
I have not received the
He
payment.
was not aware of the compensation.
My lord, there
But
is
my-
filed an
if-
application.
yes,
for that.
Yes, my lord, file this
My lord,
application.
if he filed an application, that will be considered.
No, let him come.
No. My
An
lord,
application was filed that has already been considered.
A order has been passed.
I'm sorry to say it has.
No, my lord, allow him.
My lord.
Keep short manner.
If my lord, your lord wanted to get this matter, my lord, then my lord, your lordship thinks that your lordship has the jurisdiction. So my lord, he must file arbitration, fresh arbitration. We must consider fresh arbitration.
His prayers are not so. His prayer is challenging the notice. He has to bring it on record.
Notice, challenge my lord, as you are
This
not.
is his prayer. He has come to know about all this only upon your submission of report. Before that, he was not aware at all. So since you have submitted reports in this writ petition, let him come with a supplementary affidavit. These facts need to be brought on record.
He must come with the exception. In exception, he is nothing to, he never.
Exception is not sufficient. He has to bring these facts in the writ petition by way of a supplementary affidavit.
My lord, by exception, he must, my lord,
Exception is limited to your report, not the entire facts.
my lord, in exception, my lord, he can.
He can
my lord,
controvert, my lord, by
but
these
on the-
documents. Yes.
my lord, now every day.
And
time,
you
my lord,
say
he
that an
taking
order
time.
can be passed on the basis of his exception.
No, my lord, I am not.
A supplementary.
My only
affidavit is
submission is lordship regarding his only agreed with the compensation regarding his lordship, how he's sitting tight over this property for so much time, lordship, because it is hampering our. So, my lord, if he not praised this, only the
Till
first.
the writ petition was filed, he was not aware that was acquired. Right? It was only upon your submission of report that he came to know that the property was acquired. acquired, compensation paid, a 3G1, all this has come in your report, not prior to that.
But
It
he
was
never
not
prayed for filing any supplementary affidavit, Lordship. Before that, he never prayed for any supplementary affidavit. That's the
Since you
situation.
raised the point today,
My
that it is not in the prayer, so it should be incorporated.
My lord.
Yes, otherwise it could have been allowed on the basis of subsequent events, on the basis of your report, that could have been done. But well, for abundant precaution,
My
please
lord.
come back with your supplementary.
I'll do that.
Heard learned counsels for the parties. The petitioner initially challenged the notice.
Page 48, Your Lordship.
Dated 18th December 2018, issued by the
Officer in charge, Your Lordship.
officer in charge, Baharampur Farakka Highways Limited, directing the petitioner to demolish the unauthorized construction in his property. Paragraph. Upon receipt of the reports in the form of affidavit filed by the respondents, the petitioner learned that the plot in question was acquired by the National Highways Authority of India, award under Section 3G1 of the National Highways Act 1956 declared, and arbitration held. The petitioner seeks to submit a supplementary affidavit in view of the facts revealed from the reports in the form of affidavit, along with relevant documents. Paragraph, let the matter appear under the same heading on in view of the following and along documents. Submit a supplementary affidavit annexing relevant documents in view of the 19th February. Next.
19th hearing the affidavit completed. Put in mind, I am for the petition on others. 14-15 দুটো একসাথে though the matter has come under the heading motion, but in this matter affidavits are complete.
So let it appear as a hearing matter.
Motion এসে গেছে।
No, it is at the motion stage. Reports are called for, not affidavits.
No, the affidavits state file affidavit. We have also filed reply. No,
State file affidavits.
Item number 19, my lord. 14, the affidavit filed by the state. Sir, naam nahi, should be Advocate Bar Association. Opposition.
Let it appear as a hearing matter.
Reply আমাদের দেওয়া হয়ে গেছে।
We have also filed reply.
Let it appear as
Yes. Well, the interim order passed in this matter going to expire on 31st.
31st January, it will be extended for some time.
I'm led by Mr. Probal Mukherjee, madam. I'm led by Mr. Probal Mukherjee in this matter.
Affidavits have been exchanged. Paragraph, let the matter appear under the heading Group 1 hearing on 26th February. Paragraph, the interim order granted earlier is extended till 31st March or until further orders, whichever.
At the top, madam.
Yes.
On 26th February.
Let us. Next. Still.
But I appear for the KMDA. These four matters are identical, 16, 17, 18, and 19. That on the, I have raised a preliminary issue with regard to maintainability of this writ petition on the ground of suppression. Because the proceeding which is sought to be challenged in the instant writ petitions had earlier been challenged by some other landowners, and that was affirmed by the single bench as well as the division bench. In both the matters, my learned friend had occasion to appear. But this fact has been totally suppressed.
But you have filed the judgments also.
Yes, I have submitted 3 judgments, and on the other day, my lord was pleased to direct me to supply a copy to my learned friend to answer on that.
Yes.
I have supplied him.
Yes.
But then the other side has completed his argument, I think.
No.
Because
This is the prelim. What is the argument?
no,
On the point of maintainability, I raised.
Because the suppression of material fact is not relating to maintainability of the writ petition. It will appear only after going into the merits of the matter.
No, sir, no.
Then it is all right.
If there is suppression of material facts, the writ petition will be dismissed. Fair enough.
I'll come to that point later on. Let me place the facts of the case.
No,
And
sir, I am sorry.
On
Please,
this,
respond to the submission made by the
suppression of
by
material
learned
facts.
counsel.
I also want to rely on 2 judgments on this point, suppression.
Yes.
That is settled law.
Yes.
If there is if the
I have brought the judgment of the Supreme Court. My learned senior friend knows that very well.
Getting of judgments that they are not
Let
entitled.
him, because same proceeding was challenged in a writ petition. Then it was carried to the division bench. Division bench affirmed. Pursuant to the direction passed by the Honorable Division Bench, payment was made, and then the writ petition was finally dismissed. I have placed 3 orders.
No, let me place.
Mr. Talukar, please place the orders one.
Yes.
Relevant portions.
Let me for refresh.
What is under challenge in the present writ petition?
Yes.
Present
That
writ
has to be.
petition, he is the owner of RS plot number 301 in village Makra. No, that is the challenge. The individual petitioners have come.
My lord,
আচ্ছা
আমি যশের চাইছেন পয়েন্টটা আমি রিহেজিটেট করি, হ্যাঁ বসুন তো, জাস্ট আমি নট শুনবেন।
The land
If it-
acquisition proceedings.
My lord, kindly have a look. The prayers at page 18 starts from 18 and 19. Plus, you will find that LA case number 25, Act 2, CMDA of 1984-85. To recall receipt, the purported land acquisition case number 25. So 25 of
more is there in respect of the land of the petitioner, because in that case, several hundreds of lands were involved. I am not concerned with the other land. I am concerned with my own land in respect of the land of the petitioner. Why my learned friend is omitting that, I can't understand. To mislead the
I would like to see whether the earlier writ petitions were in respect of the entire proceeding or only with respect of the land of the petitioners therein.
Yes.
That has to be seen.
Yes.
Yes, which is the earlier writ petition?
Yes.
I will come to that. Before that,
I would, because since maintainability is challenged,
maintainability.
Mr. Talukdar will have the first right of audience. We'll go into
on the earlier occasion,
that report, the maintainability petition has been challenged on other ground, not on this point. Your lordship, kindly see the report of this KMD.
He can still challenge. There is no difficulty.
Pardon?
It's not barred by law. He can still challenge the maintainability.
I'm grateful to your lordship.
It is not included in the report. Yes.
my lord,
Writ petition of the earlier writ petition.
earlier writ petition I have brought, my lord.
I would like to see the prayers.
In another proceeding, my lord, this records of the writ petition as also the records of the appeal, my lord, was called for, and that was tagged with another matter pending in other court. But I have a copy of the writ petition, if your lordship kindly looks the prayer.
What is that?
ওই যে বাঁকড়া নাগরিক ফোরামের
কোনটা দিলেন?
রেড পিটিশনটা
No, petition in which? WP number?
WP number 15608
608 of which year?
2004.
2000. May I submit one thing?
Here the entire proceeding was challenged,
And
which includes your land also.
That is 2004.
yes,
That is 2004. But my case ends before that. I will come to that point.
Let us.
So subsequent, even like I am not bound to disclose, because before that my case ends.
You have challenged LA case number 25
Yes,
of 1984-85.
yes,
The same LA case was challenged in the earlier writ petition.
in respect of my own land.
In the earlier writ petition, the entire LA case was challenged, not only in respect of the petitioners therein.
Yes.
Since the entire LA case was challenged as a whole, that included your land also.
Yes,
Yes.
I will come
So
to
if
that.
there is an
Wh-
order
whether-
in respect of the entire
Whether
LA
that
case,
order covers the present writ petition or not, that will consider.
has to cover.
No,
Because
no,
it's the
no.
entire
I will explain. That does not cover.
Let us see. My lord has seen the prayer.
Let me
Now
present my case. Thereafter he will.
Acha, let me place this orders passed in the writ petition.
Yes.
Initially, my lord, lordship kindly take up the order dated 17 December 2004. And my lord has seen that advocate on record and who appeared there.
Yes.
My lord, this is against an interim order passed in the writ petition, my lord, an appeal was carried to by the KMDA. My lord, initially the appeal was my lord, taken up for hearing on 17 December 2004. My lord, may I read the orders need to be my lord placed. After having
Mr. Taluka, I'm
12,
sorry,
12:30.
yes.
Yes,
I think you
that's-
can continue because the
that
mention
I was
matters are
also
waiting.
thinking. Let us come back on some other day.
Yes, because 12:30 I take up.
If it is
mention
convenient
matters.
to your lordship and of course to my learned senior friend, 2nd we can come back, 2nd February.
Yes, you can. Because this issue
February.
has to be decided
Yes.
first. The maintainability issue has to be decided first. If only it is found to be maintainable, I'll go into merits.
Yes.
Yes.
But merit is required to be considered to go into the fact of whether it is suppression of fact. Because my fact is different, their fact is different.
Whatever the facts be,
Maybe.
if the entire case has been challenged in the earlier writ petition, which includes your land also, you cannot make a fresh challenge.
No, I showed to your lordship that these judgments are infactual so far my case is concerned.
That's certainly not, and the
Certainly
law
not.
requires
I
one
showed you-
must come
I
with
showed
clean
you
hands. Here,
Why is-
unfortunately, in the single bench, before the single bench and the appeal bench, my learned friend had occasion to appear. In spite of that,
Maybe
not a
lawyer may
single
be
whisper
same,
has been made in the
but
writ
the
petition.
facts are different. Lawyer may be the same, but the facts are different.
Very well.
Her learned counsel for the parties. Paragraph, let the matter appear under the same head. On counsels for the parties on the ground of maintainability of the writ petitions. Petition.
One thing,
No,
Gillard,
no,
one thing. Would your lordship please to call for the records of the writ petition? I'm told, my lord, in that proceeding which was tagged, the records of this disposed of cases.
Due to some other bench.
No, that has been detached from that. And
If you can file a copy of the writ petition, that will be sufficient.
that is only the copy I have. My lord, the affidavit in opposition which was filed.
Give
That
me a copy of the writ petition on the next day. That's it.
yes, that.
So this is your brief. 2nd February?
2nd February অসুবিধা আছে দাদা? 2nd February বোধহয় মঙ্গলবার।
Thursday.
মঙ্গলবার।
Friday.
Huh?
Friday.
Oh, Friday. Friday.
on the ground of maintenance of the writ petition, huh? Right? Paragraph,
On the ground of suppression of material fact, you will also kindly note it. Because his argument is suppression of
If
material
anything,
fact.
anything
No,
after,
not on
after
other point,
this,
not his other
after
point.
this, if
Writ petitioner
anything
has
remains
no-
to be
no,
challenged.
whether the writ petition has locus standi or not, that is a different point. That is maintainability.
is maintainability on
No,
any
no,
ground,
no.
on any ground.
No. Then he can take another point in the next occasion also.
If he is challenged, he has to be given the first right of audience, and he can challenge the maintainability from any angle.
Maintainability on the ground of incapacity of the writ petitioner not. But he is saying that it is not maintainable because of suppression of material facts. That should be noted. I would give answer to that only.
I have challenged,
No, not
I have
that-
raised the
that
point of
Same
maintainability.
heading on
Why,
2nd February 2020.
whether, whether anything remains to be challenged in this writ petition.
Yes, that I will.
Till 19, 17, 18, 19, same.
19, same order, same
Same,
order,
same.
same order.
16, 17, 18, 19, same order.
May I check the?
Yes, yes. Mention.
Huh?
12,
Right.
it has been-
Excellent.
30. 1236, matter item 595.
This is my last. Service to এইটা
রোল মামলা এইটা জাহাঙ্গীর জাহাঙ্গীর
Yes. অন্যটা
This has been challenged the notice of tender issued by the district magistrate. Before that, my lord, I am drawing lordship's attention. In earlier occasion, a order has been passed by this honorable High Court. Now, my client, my lord, got the tender license, my lord, for mining lease. Very early, my lord, since 2006. Subsequently, in the year 2018, they have refused to accept the money, and the extension has not been granted. Now my client come to this honorable court, and an order has been passed, page 159. Order passed 159. This has been passed by Justice Tandon.
159.
15. Got it, lordships?
Yes.
This order only direction has been given to the authorities to consider the sins. Well, on the basis of the hearing, an order has been passed. Got it, lordships? Well, on that basis, my lord, the order has been passed. 165, page 165.
Yes.
This has been, my lord, this has been prayer of the petitioner for renewal. It had been rejected by the authority council. This has been challenged by a fresh read application. The next page, page 167.
What was rejected? The issuance of transit pass, renewal of mining lease.
Renewal of license.
Yes,
This has been, my lord, rejected. That has been challenged by this honorable court. My lord, the page 167. My lord, there is, my lord, the direction has been given for filing the affidavits. My lord, that affidavit has not yet been exchanged. Matter is still pending. This is the one aspect.
This is before some other bench.
This is the, my lord, the deed application is pending. Relating to that, my lord, the extension of the tenure renewal. This is the one aspect. Second aspect, my lord, the tender notice has been issued. My lord, they kindly see the tender.
During pendency of your representation?
during pendency. This is the one aspect. Second aspect, my lord, the tender. Tender, my lord, the was 170. This has been passed by the district magistrate. Got your lordship, page 170.
Yes, yes.
I am drawing lordship's attention, page 172.
Yes.
This has been mentioned, the plot number. The same plot. 4259, 4289. 59, 4259. Page 17. Got it, lordships?
Yes.
This is, my lord, plot number has been mentioned, and the area has been mentioned, my lord, 4.85 hectares.
The entire area is was allotted to you.
No, I'm drawing lordship's attention.
This includes your area also.
Inclusive. No, that is the total area 4.85 hectares. My responsible submission in the same plot, total area is 74 point something. I am not 74, sorry. 74, 70, total area is, my lord, 74.50 acres.
Granted 18 decimals.
My lord?
You were granted 18 decimals only out of the entire area.
No, 18 decimal is my land.
Yes, that is what I'm saying.
No, thereafter 10 acres already allotted
To?
to my client. Total 18 decimal is my personal land. And 10%, only 10 acres has been allotted to my clients. I drawing lordship's attention. This is the malified intention of this case, my lord. Whole things, my lord, appear page 162. This is an findings of the SDLR. And this refers to the district land and land reform, page 162.
Yes.
The whole things, my lord, observation has been made. This is the total area of such and such.
10 acres.
10 acres allotted to me. And apart from that, 18 acres,
Your own land.
own land.
This is plot number 4259.
Same plot. This is the one plot. Total area is 74.50 acres. This has been for the purpose of mining. My responsible submission twofold. One fold, the total area has been announced, or already, my lord, the notice has been served without having demarcation. Second thing, my lord, one matter is still pending before the Honorable High Court. They are not interested to filing the affidavits in spite of the direction. I draw lordship's attention. I draw lordship's attention. This is the procedure for auction. Even before issuing the notice auction, my lord, kindly clause 2. The specification and demarcation, it requires, it is a mandatory. 5 auction rules, 2, paragraph 2. My lord, before inviting tenders. Issue tenders.
Identify and demarcate.
Identified demarcation. My lord, twofold things, my lord. In the plot in question, my own plot is there. Secondly, my lord, 10 acres plots, my lord, which was allotted to my client since long. This matter is sub judice before this Honorable Court. I am still in possession. That has not been decided by the High Court. This matter is pending. They are not interested to file the affidavits in spite of the direction. And secondly, my lord, the rules itself, before issuing the tender notice, there must be a demarcation. That has not been done. So my responsible submission required to be stayed and decision protected.
Yes, Mr. Bandapati.
My lord, in this writ petition, my lord, the petitioner challenged the
Yes.
notice dated 8th January 2022, 2024, P25, page 170.
Yes.
My lord, it is, my lord, the notice for inviting application and bid documents along with annexure for e-auction through competitive bidding in online mode in respect of 11 numbers of Blackstone blocks. 11 numbers of Blackstone blocks.
But in the next page.
That is in. Well, it starts, my lord. The auction procedure has already been started. My lord, you will also kindly turn to page 172.
Yes.
Last month portion. Auction calendar with critical dates. Document submission payment starts dated 9th January 2024 at 10 a.m. Document submission payment date 22nd January 2024, 5 p.m. Document submission payment approval start date 23rd January. Document submission payment approval date end date 26th January. Auction date 27th January.
Yes.
And then thereafter, my lord, auction end date 27 January 5 p.m. This is the my lord, schedule.
We opened on 27th January. Yes.
My lord. My lord, petitioner was earlier granted long-term mileage. But possession has been handed over. There are several litigation before this honorable court. And lastly, my lord, this honorable court, my lord, passed the order, which my learned friend, my lord, just shown before your lordship. Page 159. Justice Tandon's order. And accordingly, my lord, pursuant to the Honorable Justice Tandon's order, a hearing was conducted. It starts from my lord, page 165.
That was
That is
rejected.
Rejected on which ground?
That is challenge.
Which ground? That is pending.
That
That
is
is
challenge.
pending. Yes, my lord, that is
Yes.
challenge. But that is pending. I'm drawing your lordship's kind attention, my lord. Last portion.
That
So when this challenge is pending, Mr.
My lord.
Bandyopadhyay,
My
could
lord.
authority have
But
issued a
total
fresh
land
order?
is not his plan, my lord. I'm not instructed, my lord, today. Just he has mentioned the
How
matter
did
on the
I
earlier.
the remaining land?
My
You
lord.
have said part.
I
Auction
don't
is
know,
in
my lord. I have no such instruction. Just I have briefed to.
Page 172 says 4259 part.
Yes, part.
So which part, which land?
I have no such instruction, my lord, at this present moment. Just I have received
So this
half an hour.
get instructions.
Well, I shall take instruction.
Then in the
But
meantime,
my lord, you also kindly see the last portion. Hence, the petition. Last page 166.
that is challenge. That is admitted.
The petitioner has miserably failed to produce any document for renewal of his lease deed within the period of 6 months prior to expiry of the lease date, that is the 13th September 2015, provided in sub-rule 1 of Rule 12 of the West Bengal
So
Minor.
it has been rejected on a mere technical ground.
My lord, that is technical ground. That is, my lord, it's under challenge. Hence, considering the above fact, it is hereby ordered. There is no scope for renewal of mining lease in favor of the applicant company at this point of time. However, he is at liberty to participate in the e-auction process of the demised land vested to the government as and when the same is put to auction by the district authority. That is my lord challenge that is pending, my lord.
Yes.
Now this, my lord, auction notice. I am not
Should not have
instructed.
been issued. Should not have been issued, at least in respect of the petition.
Let me come with the instruction, my lord.
Yes.
Let him participate, my lord. Let him participate in the auction process. What is the difficulty to participate in the auction process?
Court rejects his prayer, not before that. The direction is under challenge before this.
My lord, that is pending, my lord. I don't know what step he has taken for hearing of the matter.
that is I have annexed the document.
It is due for affidavit of
My lord,
opposition
that is
of
due.
not side, which has not been filed.
Yes. I don't know, my lord, who is appearing in the learned advocate, my lord, whether he has filed or not. It is the submission of my learned friend.
That is
State.
also.
And you cannot apprise the court that.
I
it is
cannot.
filed.
I cannot.
So let this be state for the time being. Heard learned counsels for the petition. It is contended on behalf of the petitioner that
ওই বিটটা দিয়ে দাও বিটটা দাও আমার বিটটা দাও আমার বিটটা দাও
the petitioner was granted long-term mining lease in respect of ten acres of land in plot number 10 acres of land belonging to the government in plot number 4259 and 18 decimals belonging to the petitioner. The first writ petition was for refusal of the for
refusal of the
renewal. Upon refusal of the authority to renew the said lease, the petitioner approached this court in a writ petition being WP 6812.
Several litigation, several.
Two are there.
4 or 5, my lord.
4, 5.
4 or 5. I'm coming, my lord. অনেকগুলো রিপিটিশন হয়েছিল
কোথায়
এখানে
না না সেটা তো অন্য ইস্যু
আরে ওষুধে অন্য ইস্যু না জজ সাহেব সেটাই তো জানতে চাইছি
যে পয়েন্ট আমি রেজ করছি
No, I am on renewal part.
রিনিউয়াল পার্ট মানে
রিনিউয়াল
WP 6812 within bracket
Procedure.
W of 2018 and by an order passed on 11th June 2018, a coordinate bench of this court directed the competent authority to take a decision on the application filed by the petitioner for renewal of the mining lease. Stop. The application filed by the petitioner was taken up for consideration by the concerned authority, who by an order, concerned authority being the Joint Secretary, Department of Industry, Commerce and Enterprises, who by an order passed on 23rd July 2018, turned down the prayer of the petitioner. The petitioner carried the said order in appeal. And by an order passed on 8th April 2019 in WP no appeal na ওটা কেটে দিন the petitioner carried the said order line টা কেটে দিন ওখান থেকে challenging the said order the petitioner filed a further writ application being WP 20885 within bracket W of 2018 and by an order passed on 8th April 2019 in the said application, a coordinate bench of this court directed exchange of affidavits. Stop. Paragraph. Learned counsel for the petitioner submits that affidavits are yet to be exchanged and the matter is pending. Paragraph. In the meantime, the respondent authorities floated a notice inviting applications for e-auction for grant of mining lease in respect of a part of plot number 4259 and declared the auction start date as well as auction end date as 27th January 2024. Stop. Paragraph. Learned counsel for the petitioner submits that the plot involved in such e-auction has not been identified or demarcated in terms of Rule 5 within bracket 2 of the West Bengal Minor Minerals within bracket auction bracket closed rules 2016. Stop. It cannot be ascertained as to whether the plots allotted to the petitioner is included in the auction notice. Stop. Since the writ petition challenging the order of refusal is pending, comma, the authority could not have included the plots allotted to the petitioner in the e-auction. Paragraph. Learned counsel for the respondents seeks to take instructions in this matter. Paragraph. Let the matter appear under the same heading, under the heading motion. Under the heading motion on 22nd February 2024. Paragraph. The e-auction notice dated 8 January 2024 be stayed till 29th February 2024 or until further orders, comma, whichever is earlier. True, the affidavit of service.
Lord, the page 162, one more, my can be said, page 162.
Yes.
In paragraph 4. A similar thing appears in the next petition, my lord. Paragraph 4.
Yes.
There's the next petition is the name of the next petition. Paragraph 4.
Next matter.
Next matter is the something is separate. Another read application is pending. This is read application challenging the rules as amendment rules. It is the virus challenge.
Supplement.
Here is my lord, just I'm drawing lordship's attention. Here is my drawing lordship's attention, page 62. This is the name of the second petition is already appeared in this. Next, my lord, the page
Give me a minute.
250.
Page 62.
Page 250.
Page
250.
What are you challenging in this?
Challenging notice, same tender notice.
The same notice.
Same notice. The same notice.
So what is the difference that you say?
This is the, my lord, I am referring, my lord, another read application challenging the rules, amended rules. That has been challenged before this read application, that is pending. Affidavit direction was there. There is no affidavit has yet been exchanged.
From page 250, nothing can be made out. Which writ application, what was challenged?
That is, my lord,
The renewal has been refused.
It has been refused.
And you have not challenged that.
Challenge, it is a extraordinary, my lord, separate things, another. Not the so far the my another petition on 162 I am indicated.
This did not be dealt with at this stage.
At this stage. Lord, the same notice has been challenged.
Where is the writ petition challenge? The two writ petitions?
No. This is, my lord, the challenge to the same notice.
Yes, but you are a leaseholder, isn't it? You are
a leaseholder.
You are a lessee. Your renewal was rejected. You filed a writ petition. Is this the same order that you pointed out in the earlier writ petition?
No. My submission, my case was rejected on the grounds of amendment of the new rules. That rule has been challenged.
Where is that order?
That is, my lord, page 250.
No, 250 is just a paragraph. It doesn't say anything.
No, order.
The order, I cannot make out what writ petition is this. Please place your case.
Lord, 1 minute.
Why are you challenging the notice?
Notice itself, my lord, the separate grounds, my lord, the demarcation has not been met. That rule has already, my
Where is
lord,
your
indicated.
area?
That is,
Where is
that
the
is also.
refusal of your renewal?
That has been, my lord, kindly appreciate another, earlier writ petition, page 162. That findings, once, earlier writ petition, page 162.
Where is the refusal of your renewal by the authority?
This is my refusal, not the
There is
renewal.
no refusal.
Not refusal. Refusal, my lord, on the ground of amendment of new act rules. This is not the separate points. The rules has been challenged in the instant case. Since the prayer was rejected on the ground of, my lord, the
Where is that order of rejection in this writ petition?
only 1 minute. Yes, 34. Huh? No, 234. Oh, my lord, the operating portion start from, my lord. It is page 234 is a operating portion. 192 234. 199.
Yes.
Only 1 minute. 199 থেকে এসেছে। হ্যাঁ? 190
কি চ্যালেঞ্জ হয়েছিল সেটা এখানে
191 started from 191.
Yes.
This is the big judgment, my lord, and it appears before the division bench. This is the judgment of the division bench 190 started from 190 and the operating portion, my lord. The page 234.
These are the same writ petitioners.
No, another.
Another.
Please place this.
They are
case, sir.
also
I cannot
involved
understand
with
anything.
No, my response submission, the plot is same.
Yes.
Plot is same. Earlier writ petitioner is a separate. Here is the writ petitioner, other writ petitioner. Remaining portion is in the same plot.
They were also
Please forget about others. Please place your case. These
Is it-
writ petitioners. They were granted mining lease.
Mining
Then
Then, my lord, that has been, my lord, rejected on the ground of the new amendment of the new
where
rules.
is that rejection order?
That has been challenged before the order high courts and thereafter went to the division bench. Division bench order, my lord, the kindly place the 19.
Rejection order.
This
Renewal
rejection order
rejection
is
order.
correct. Rejection order time is
Come one by one.
rejection order not challenge করেন my lord, the page 189. Page 189.
This is the notice for closure.
Yes. By virtue of that, my client is affected. Thereafter, litigation is going on.
You are Rajgaon Stone.
Yes. This also name also appeared in the earlier petition, page 162, the inquiry report. This has been noticed. We have challenged.
This was challenged.
Yes.
Yes. Then you challenge this before the single bench.
Single bench. Thereafter went to the division bench.
Single bench refused your prayer.
Refused. Went to the division bench. And division bench, my lord, the lot of cases was similar point, lot of cases was taken up for hearing and the similar judgment order passed.
You are one of the petitioners.
One
before
of the
division
petitioners.
bench. Yes. And where is the operative part?
Operative part, my lord, page 234.
234. The division bench judgment.
Division bench judgment. In the elaborate judgment. Huh? 230, 32, the
Here it
continuous.
says that the authority refused to grant renewal. So where is that refusal? Page 189 is a notice asking you to stop mining.
Stop. Thereafter, no renewal has been done.
But please come to page 233.
233 order. Lord, this has been, Lord, they have.
Decision taken by the authority for refusing the renewal. Where is that
So
decision?
that has been indicated. But refusal is not, my lord, that way. By that way, my lord, the closure of mining. This has been, my lord, the.
Closure and refusal for renewal.
Though
are
I
the
do
same
appreciate,
thing.
I do appreciate this is a separate
They're
thing.
not the same thing.
Though I appreciate, my lord, this is a separate thing. But this has been happening. And after that, my lord, the rule has been challenged. In the division bench, the rule has not challenged. Of division bench, after that, my lord, the rule has been challenged.
Which rule has been challenged?
That is, my lord, the rule, my lord, the amendment rule that has been placed to 50. That matter is still pending.
250, there is nothing in 250, only call for affidavits. I cannot make out what is the petition.
This is, my lord, the order, my lord, affidavit service file to be kept to the record.
Yes,
The
what I
respondents
said.
given liberty to file the affidavit in opposition within 3 weeks, respondent after elections vacation. এর আগের অর্ডার গুলো কই দেননি তো
And this division bench order also doesn't help you. Because it says until it is ultimately determined by the
ultimately
authority.
yes giving
It has been determined by now.
this has been, my lord, this order judgment has been passed, my lord, I am not that way. Yes, what has happened that I am telling. And by virtue
2014 judgment, 10 years back.
yes, thereafter
After that, the authority has decided.
thereafter has not been decided. Now they have taken the decision. Now the taking decision. And I raise the point, my lord, the rule 5. This also, my lord, the
It is
technique
directed that the operation of the order will remain stayed. Which order?
that nothing has been done thereafter.
Which order will be stayed?
My lord, the order means, my lord,
The judgment says order of renewal. There is no
order
such order.
means that is the closure, that is the order.
That cannot be the order.
However, my lord, my lord, by virtue of that, after that, my lord, long period, the authority, my lord, decided to issue the tender notice on 8th.
Yes, how are you affected? I do not find that you are affected.
No, that is, my lord, affected, my lord. I drawing lordship earlier repetition page 162. My name indicated in the inspection report. Kindly appreciate.
Did the other petition din to?
I am just drawing lordship's attention. Page 162. This is, my lord, the report filed by the subdivisional officer to the
Yes.
the paragraph 4. 162, paragraph 4. Now, the bottom portion of Rajgaon Stone Company Limited. This is the petition. So my existence there.
This is in 2007.
Yes.
So please show me your existence in 2024.
Existence, my lord, 2007. My responsible submission since 2006 we are enjoying.
Yes, this 2007 document says that you are in existence.
Yes.
But we are in 2024 now.
2024, my lord.
So please show me your valid legal existence as on this
No,
date.
thereafter several litigation is going on. Authority did not take the steps. Now they have taken the steps in 2000.
Please show me those litigations, sir. Where, how are you involved? The last renewal was till 1972. After that, there was no renewal.
Well, we have paid the royalty. December 2016, we have paid the royalty.
Doesn't entitle you to occupy the land.
One of the only one. Annexator ঠিক করে দেন। My lord, the page 23, 236 to 249. Page 23, the royalty already payment, payment received. Page 236 to 249.
Payment of royalty doesn't indicate your right.
Position is still in my case.
Your
Position.
right. Here, you in the earlier case,
Earlier case is separate.
there was a specific case.
I do
you had
appreciate.
a ground.
I do appreciate.
But
In
here
case, my
there
lord,
is no ground.
in case, my lord, since 2007, inspection is there, conducted by the authorities, and they have taken they have since we are in position, still we are in position, and up to 2023, the royalty of the payment has been made.
Another issue is I have stayed the auction in the earlier case.
Yes.
This is the same auction
Same
that is being
auction,
carried.
same.
So this will be applicable here also.
Yes.
So let the same date be fixed, because I'm not very convinced with this matter.
That is to my lord. My lord.
You are not being able to show me any.
That's true, my lord. I do appreciate. Let the same matter
If
be.
you want to annex, come back with supplementary affidavit, you can do that.
I see. My lord,
Renewal order is
on the
something,
same date.
notice is something else. I am not convinced.
That's true. Well, I list of date, my lord.
Mr. Bandyopadhyay is appearing in this matter also.
Same.
I have
Let it
not
is.
seen the order. Let it appear with the other matter on the next.
Along with this.
এটা
Yes,
actual
yes.
full order office for the parties.
It is-
Let
along
it
with
appear
this.
under the same heading. On or yeah,
22nd.
22nd February. Where is the service? If it is served, I can pass an order.
Yes.
Notice was copy was served.
Let me find.
নাম পেয়েছি সৌমিত্র বন্দ্যোপাধ্যায়ের জন্য।
Served. Mr. Bandyopadhyay, appear please. Affidavit of service. None appears for the state respondents despite service. Mr. Bandyopadhyay, who is present in court, regular as quorum, copy service. Please serve a copy of the repeat to Mr. Bandyopadhyay. Yes. তারপরে Hardland counsels for the party.
ঠিক আছে।
Let the matter appear under the same heading on
একটা copy দিয়ে দাও না।
20th February, same day.
Same
let it
day.
appear. Your purpose is served.
Much of
That's one matter.
Mention matters could not be taken up.
That's one.
First matter, it can be resolved within a minute. I
Within a
believe
minute.
Mr.
Please.
Anwar will pay leave to withdraw this application.
Lordship, these are
To
having been
favor and to
purchased.
support the divisional commission. That is the.
This is not short.
Yes, let me take up at least one matter in the mention.
Yes.
Lordship.
It's a very short matter. Proceed, the order impugned is appealable.
86 page and 19 July.
Yes, yes.
Lordship. Rule 50.
Yes, page.
Page 86. Impugn order 19 July 2022. This order has been passed by GDM. So now I bring liberty to prefer appeal within a stipulated time so that delay may be caused.
The order passed by the Additional District Magistrate and District Land and Land Reforms Officer, Purva Bardhaman, on
19 July, page
19 July 2022 is impugned in the writ application. Paragraph, the order is amenable to appeal. Under Rule 51 of the West Bengal Minor Minerals Concession Rules, 2016. Paragraph, learned counsel for the petitioner. The petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of his grievance. paragraph in view of the above, the writ petition being WPA such and such is dismissed as not maintainable. Dismissed for non-prosecution. Dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Limitation is over.
Yes, it is long expired.
Paragraph, in the event the petitioner prefers statutory appeal within
1
month. or
1
2
month.
weeks.
1 month. 1 month. Or 3 weeks.
Within 3 weeks from date, the appellate authority shall consider the appeal on merits without dismissing the same on the ground of limitation.
That's every service kept to the record.
Show the affidavit of service shall however be no order as to costs or adjacent favors.
My lord, before lordship rises, my lord, this is with regard to the matter which your lordship fixed on Monday, my lord.
Yes.
Since your lordship has not endorsed any leave, my lord, I'm not able to short service the learned government Peter office, my lord. If your lordship kindly indicate, my lord, that it will be taken up on Monday, I can short service them. It has been file number has been provided, my lord.
File number has been provided. Didi, order taken up on to be taken up on Monday করে দিতাম সোমবার 89 service নিচ্ছেন আপনি জিপি অফিস to be taken up on 29.
I'm so grateful, my lord.
ক্লিয়ার হয় না থাকে হ্যাঁ ক্লিয়ার করব বাবা ক্লিয়ার থাকবো না
হ্যালো আমি কোর্টে ছিলাম বললাম না আমার একটা ম্যাটার ছিল চলছিল ওটা আপনি কোথায় আছেন এখন বলুন এই কোর্টটার কারণে শেষ হলো আমার ম্যাটারটা আমি কেন কাকু কোর্টে যেতে পারবো না না আপনি কোথায় এখন এক্স্যাক্টলি আছেন কোর্টের দিকে ই গেটের সামনে আছেন তো থাকুন ওখানে আমি আপনাকে নিয়ে আসছি ওখানে থাকুন ই গেটের সামনেই থাকুন আমি আসছি
দেখি ওকে বলো
মাইন্স মিলিয়ন এন্ড ওয়ার্ক মাইন্স এর বইটা এক্ষুনি দিয়েছিল পিআর অ্যাক্ট
আমি তো আচ্ছা আমি ওই নোটিশটা দেবেন তো হ্যাঁ আমি মোটামুটি আপনি একবার ফোন আমি তোমার কাছে যা চোখে নোটিশ দেওয়ার দরকার নেই আমাকে বলেই হবে মানে
হ্যালো,
এটাতে বস
হ্যাঁ বলছি।
ব্যাগটা এখানে
বলছে, তুমি এক কাজ করো না, আমার ক্লাসের নম্বরটা জানো? কোন ক্লাস? কোন গাড়ি? ওইখানে আছে ওখানে সমীর আছে সমীর ওখানে থাকবে ওখানেই আছে নাইন 9437 946509997
হ্যালো, এটা কুসুমের নাম্বার না? কুসুমের না? কুসুমের?
সমীর
কুসুমের? কুসুম?
ঝগড়া করছিলাম যে হাতে ছুটতে হবে নানা করতে হবে
কোথায় ছিল
তোর আমার জন্য খাবার আনার কথা ছিল সব রান্না করে অকেশন
কোথায়
হ্যালো হ্যাঁ এই তো 10 থেকে বেরোচ্ছে এই যে যোগাযোগ নেই স্টেটাস দেখালো
নব্বই না 650 ওপরে ওগুলো কত নম্বর
এই তো সবাই এরা একটা আগে থেকে চলছে সেগুলো মোটামুটি বড় হয়েছে বড় টাকা আর 20 তারিখ কাঁপছে আমি চিকিৎসা করেছি আমাদের একটা রিস্ক হয়ে গেছিল যে অত টাকা না করে
হয়ে গেছে
প্রবলেম আছে লোন আমিও ভাবলাম কি এটাই खेल वही इस बार ऐड करते हैं बाकी मैं আমাকে টেস্ট করতাম
না না আজ
একটা দিয়েছিল নম্বর টাকা দেন আবার মানে অন্যদিন আগে একটা সত্তর মাসের আড়াই মাস পর চেক দিল ঠিক আছে আড়াই মাসের नवंबर बाकी तो दिसंबर बाकी जनवरी
New applications, item number 1.
Lordship.
My lord,
I cannot allow this recall application because I have released it.
my lord kindly comes to the order, my lord, the recalling order. My lord, the order records that by consent of the parties, my lord, none of the advocates of the petitioners were present. In fact, they were not even informed that the matter is going to be, my lord. No, my lord, it was not informed for at least release. It appellate side matter, one appellate side matter of separate advocate and record was appearing, whereby, my lord, the original side matters have been, my lord, incorporated and we were not present. My lord, page 17 of the recalling application.
Page 17.
Lordship, page 16 is the notice which was given to us, whereby
The FCI was represented and the Union of India was
my lord, but my lord,
whoever was represented by their consent.
but my lord, none of the advocates of the petitioners of the
But
matter.
the carriage of proceeding was with us. But the list that was expected that
This was released on my request.
no, that's not. I leave it to Lordship. Not.
Well,
but it has
as a matter of fact, my lord, I prayed that your lordship would kindly take up the matter because the hearing was concluded. Now, my lord, your lordship says, my lord, that in view of the paucity of time, etc.
Mr. Gupta,
But
my supplementary list consists of about
yes,
7
yes,
seven
So in fact, the hearing was concluded.
and I know, but I'm a little embarrassed because I was not able to take up the matter at all. So I thought it best to transfer it to some other court who can take up the matter and dispose it off.
But one thing,
Take the matter in this court and I'm not able to take it up. This is very embarrassing for the court also.
but
That's the only reason why I sought to release the matter. So this
Milord,
application you can either withdraw or have to dismiss it in with a one-liner. But this
Milord, in fact, Milord, it was not my prayer for release. Your lordship, Milord, yes, exactly.
I've recorded that
Other application. Yes.
stated, yes.
And Milord, I first thought, Milord, that your lordship had the determination because it was hard in part.
By consent of the parties, the matters were taken up as on days list. The other matters, some of the matters were already appearing. The connected matters were taken up by consent of the parties. It's not that the release was on
No,
consent.
not the FCI had filed an application.
My ground.
Yes, not FCI had filed an application being GA2 of 2023. Not the prayers was to pass an appropriate order vacating the interim orders passed or to decide the case finally on the basis of written notes submitted by the parties to the proceeding. So that was the prayer made in the application in a part-hard matter.
Yes.
Now, to that, your lordship was probably persuaded to, and our notice was served in the 969 of 2022 in our writ petition.
Mr. Majumdar, I would
Yes.
request you not to proceed with this matter. Before this.
No, but the part-hard is there.
I'll release that from part.
No, one thing, Milord, after
Writ petition order.
Milord, after this, after all this, Milord,
Order, huh?
finally peruses this notice in the printed on the list.
It was marked part on 25th August 2022. That's page 14 of our application.
That notice, Milord, I have tick marked that.
I am aware of this, Mr. Gupta.
No, there is also an administrative note which has permitted determination, part-hard matters to be taken up with reference to a Supreme Court judgment at the backside of the cause list. Part-hard matters can be taken up by the bench.
No, can be taken up, of course.
Can be taken up if I release it from the heading.
Unless released, of course. Yes. Unless released. Not even in spite of determination being shifted to another bench, part-hard matters can always be taken up. There is a reference to a Supreme Court judgment, probably 2003 7 SCC.
আচ্ছা ওকে তো দেখা গেছে
এই লিস্টে পিছনেই লেখা থাকে জানি না আমাদের লিস্ট থেকে ওটা আসে না পাবে না তো
Now this notification was recalled. is hereby recalled to mitigate the sufferings of the litigants. The quoted part. Please see this once more.
All right. Your Lordship has pointed it out.
I would request you to go through it once.
Yes. Then if your Lordship is not in a position to take it up, then the partner has to be recorded.
I will do. I will.
And kindly not, this is not consent of ours. This is not gives,
No, by
puts us to embarrass.
The appellate side
the-
matters were also taken up in the list.
Yes, no, that's the Union of India and the supporting respondent and two respondents agreed. No, it was not our.
Representing parties.
I represent the writ petitioners.
There at all.
Because no notice was given for only one matter, right?
In the cost act, your representation is not there at all.
Notice was given for only one matter. No, not. So, what has to be released is the part has to be cancelled. Part has to be cancelled. If your Lordship is otherwise not inclined to take up the matter.
There is no other difficulty, Mr. Majumdar.
No, we kindly appreciate our predicament also. We submitted the notes.
Being very difficult for me.
In fact, I have repeatedly requested.
Yes, I have waited for such long time. I'm not being
On the
able
last
to take up the matter.
I never prayed for release.
No one prayed. I'm repeating. None of the parties have. The application seeking recall of the order passed on 13th December 2023 is taken up for consideration. Paragraph heard learned counsels for the parties. Paragraph.
Applications. I want to. তো অনেকগুলো অ্যাপ্লিকেশন আছে নাকি?
না, দুটো অ্যাপ্লিকেশন লিস্টে দুটো আছে।
এটা কি?
The matters were released due to lack of determination and not at the instance of any of the parties. Let me record that. Paragraph. Learned counsel for the applicant has pointed out that the matters were marked as part heard. Part heard to inverted comma, small letter. Paragraph. The said endorsement of part heard inverted comma be recalled. Paragraph. Since the matters were released at the instance of this court due to lack of determination, comma, the recall application is considered and dismissed. Paragraph. Original certified website copy.
There are two matters, two applications are there.
Called two applications are there.
There are two matters. You see, there are two matters.
Two applications.
No,
সেটা কোমো বলতে হবে একটাই নাকি দুটো?
No, দুটো আছে, দুটো।
GA2 is at the instance of the employer FCI. That has to be also dismissed or not something like that.
The same.
GA2 is for passing order on the basis of the notes of submission.
Since I've released.
So GA2 not requires no further.
Not necessary since I've released the matter as a whole.
Milord, your Lordship may record that in view of this order. Milord, your Lordship may kindly record that in view of this order, no further order need be passed in GA2.
Very well. In view of the order passed on.
Passed today.
Not today, the 13th December order.
13th and today. Because your Lordship is releasing the part.
No, it has already been released. This was a recall. So the order of release has to be recorded. In view of the order passed on 13th December, isn't it? The release order?
Release order is 13th December.
December 2023, comma, no further order need be passed. In GA2, GA2 is your.
Not probably that application, not this application has to be disposed of, not FCI may withdraw that application. That is probably the best way.
GA3, আমাদেরটা 3.
No, ওদের তো three.
GA2 is FCI's application. That may be.
No. In 969, there are GA3, 1828, GA2. There are two applications in two matters.
GA2 is application filed by FCI in 969.
No, GA2.
No, GA3, your applications. You also kindly see the list. In the list, it is there. There are two. There are two matters in the list. One is 969, one is 1828. There are two matters, two applications filed by them. Kindly see the list today. Today's list just recalling. আচ্ছা ওটা না আপনি আর দেখুন ওটা একটা ম্যাটার
GA2 and 3 both are recalling applications.
আমারটা আছে আপনাদের একই নাম্বার পড়েছে ভুল করে যে কোনো একটা কারণ এই দেখুন আপনাদেরটা দেখুন এই যে আপনাদের নোটিশ দেখুন
GA2 is an application for appropriate order.
এটা সংযুক্ত নোটিশ দেখুন GA2 আপনাদের
WP নাম্বারটা দেখবেন।
হ্যাঁ WP নাম্বার আলাদা 1828 এটা একটা ম্যাটার এটা একটা ম্যাটার
969 এর তো এটা তো 969 একটা বলছি।
There are two matters, two matters.
আমরা দুটো অর্ডার
Kindly see দুটো order. There are two matters in the list, 969 and 1828.
But kindly text note item number 1, serial item number 1.
GA2 is with regard to WPA number.
Not 969 has two GAs. One is 969 has two GAs.
969 two GAs. Yes.
Let me complete. GA number 2 is filed by FCI for passing order on the basis of notes of.
Set all in 969.
It's not there. It's not there.
It's not there.
Lordship may treat it on days list.
Both are for. I don't think any further order is required.
That application has to be disposed of by this bench only. No other bench can take it up.
No, not if the matter itself is released. Why does the application be?
But there are several matters. Before the release, the application was filed. Upon that matter, the release order was passed.
But in view of the earlier 13th December and today's order.
আছে applicationটা দেখুন তো।
Well, this application is with me. I have the copy.
It is in 969.
Yes, GA2 is filed only in 969.
969, there are two applications. One is GA2 is ours, GA3 is theirs.
969 GA2 is recalling, not yours.
GA2 is their application.
There are two applications, both are number 2.
GA3 is ours. GA3 is recalling.
GA3 is recalling. But there are two matters.
GA2 is in 1828. That is recalling.
That is recalling.
And 969 is GA3.
Yes.
Is recalling.
And in 969 there is also one GA2.
That by the FCI.
By FCI.
That is not there in the list also. There is no. আছে দেখুন তো applicationটা তাহলে দিন তো।
File আছে।
File. It is not there at all.
That may be treated as on days list and.
Please give me a copy.
Yes, this is the copy.
এটা যা বলে আমরা এই দুটোতে কম্বাইন অর্ডার করব।
লিস্টটা তো কত করে নিয়ে চলে গেল।
2023
আজ লিস্টে দুটো ম্যাটার আছে।
WPO number 969 of 2022.
WP একটা 15
এটা না এটা ছেড়ে দিন। GA2 GA3 দুটোই ওদের ম্যাটার।
এটা কমন অর্ডার হবে। হ্যাঁ।
এটা আমাদের লিস্টে এখানে কিন্তু এটা এখনো পেন্ডিং ওটা এফসিআই এর অ্যাপ্লিকেশন রয়েছে।
আমি দিতে বলেছিলাম যাইনি।
এইটা এই যেটা হচ্ছে আমাদের রিকলিং।
আর এটা এই 3টা
হচ্ছে আমাদের রিকলিং।
You could take this back at first.
এটা হচ্ছে পাস অর্ডার ইন টার্মস অফ দ্য নোটস অফ আর্ট।
সেটা গছ কারণ গাই
ওয়ালেট আরো অর্ডার করতে হবে কি? অর্ডার নেক্সট পার্ট আইটেম 2
বলতে
GA2 may also be disposed of in view of that.
Same order will be passed in.
as you know.
at the heads may not both the numbers may be given and the applications in plural.
যখন
তো in এত with এটা আমরা একসাথে করি and দুটো করে both the applications. Yes, next.
Okay.
Item number 3.
3, I beg to appear.
There was a direction of filing affidavits. So that has been done by the junior advocate, my lord, that your lordship extends the period and for limited period, whatever order is there, my lord, let it be there.
There is no formal interim order, but my learned senior friend have expressed that they will not take any step.
No, there is a formal interim order.
Formal order.
There is an order.
Status.
Yes.
They limited that order, whatever your lordship passed in the initial.
Further orders.
Huh?
Until further orders.
But let it be once more, thereafter your lordship.
Come back with your affidavit in
Yeah.
opposition.
After that your lordship does it.
Next time also you will not come with.
After it is heard, it will be done. Learned counsel for the
উঠতে বলো বসে থাকি কেন কিছু সবই আমি করবো
Learned counsel for the KMC. Learned counsel for the KMC seeks extension of time to use the affidavit in opposition as sought. Paragraph affidavit in opposition be filed within
3 weeks your lordship can grant me.
3 weeks from date. Paragraph affidavit in reply, comma, if any, comma, be filed within a week thereafter. Within a week thereafter. Paragraph, let the matter go out of this for the time being, liberty to mention. Please abide by this time
File.
frame. Be treated as on day's list.